Good morning and welcome to a meeting of the California Paraprofessional Program Working Group. I will begin by taking roll. Bashan,
Present.
Reynoldson,
Present.
Falmouth,
Here.
Fleischman,
Here.
Hamilton,
Present.
Judge Harper, Hartston is not here. Kirkmeyer,
Here.
McRae,
Here.
Olvera,
Present.
Justice Petru,
Here.
Robinson,
Here.
Judge Rubin,
Here.
Shining,
Here.
Sarouche,
Here.
Spiro, Torres Ambris. Oh, there you are. Okay. Torres Ambris, Judge Wiley,
Present. Good morning, everyone.
Good morning.
and Judge Yu. I think Judge Yu is going to join us later.
Both she and Judge Harper could not get coverage for their calendars this morning.
Okay. So we have a quorum.
All right. So we have a super busy and what I think will be interesting and enjoyable, throw that in there too, agenda packed for us today with a number of speakers who I want to take a moment and just thank for taking their time to be with us this morning. Because we have a number of speakers, some of whom have various time constraints, we're going to start with them today and then take public comment as opposed to taking public comment first. And my plan for the morning would be that we take the speakers and that we ask individual speakers whatever questions we may have for them at the end of their comments, because I do not think that everyone can stick around for the whole time in order to have a group Q&A. If any speaker is able to stay past their time and after speaking, I would like to listen and continue to participate. They are, of course, very, very welcome to do so, but I want to be respectful of everyone's time. And if you need to go when you're done chatting, we completely understand that as well. So with that, let me turn it over to Judge Rubin and Leah to get us going.
Well, good morning, everybody. Welcome. I'll be talking with you a little.
Is it just me or is Judge Rubin freezing?
Yes.
Yeah.
Uh-oh.
Yeah, not just you.
Okay.
Yeah, he's also actually freezing. He wanted to make a fire in his office.
All right. Well, maybe Linda, if you could put up the slide that just sort of covers the presenters. Judge Rubin, are you back?
I feel like I'm back. Am I freezing now?
No.
I am freezing physically, but am I freezing virtually?
No.
We hear you.
You can advance the slide, Linda. So did you want to kick off, Judge Rubin, our presenters, or would you like me to?
I thought we rehearsed it with you doing that.
Okay, all right. So we, as Justice Petru said, we are really pleased to be joined by a host of folks. And this list, just as a reminder, was inspired or generated by your requests at the conclusion of our last conversation around in-court representation. So you can see on the screen here who we plan to hear from. And we're gonna just kick things off starting with Arizona. As a reminder, Arizona has not yet begun its legal paraprofessional program, but when it does, the paraprofessionals will be able to represent parties in court. Ontario, Canada has a very established program where paraprofessionals are allowed to represent parties in court. And then we'll move on to some clients. We're really lucky to have pulled together clients of Triple LT in Washington, as well as LDA clients. We have Professor Moore on the line who's available to address some of the UPL issues that some of you have raised with respect to in-court representation. And then we're going to hear from some members of our working group who I think are best positioned to talk to us or share their views about this issue. That's Judge Wiley in her capacity as supervising judge of family in San Francisco Superior Court, and Nicole Robinson as our member who is, I think, most likely out of any of us to perhaps actually hire a paraprofessional. So with that, I'm going to turn things over to Dave Byers, who runs the Administrative Office of the Courts in Arizona. Dave.
And good morning, neighbors. I guess we're getting some of your cool weather over here in Arizona also. So I've been with our courts, Supreme Court, for over 40 years. I've also served on our state bar board of governors for at least 15 years. And I do serve on the ABA council that regulates law schools. I say that just because, to let you know, I've had a long background of working with the legal profession, legal education, and court administration. So as Leah says, our new rules that allow for LPs, legal paraprofessionals, went into effect January 1st, and we are in the process of implementing that. The major work we needed to complete was to put together the testing program that they have to pass in order to be certified. That's now been done, and we expect to offer the first exam in April. Right now today, we have about 100 people on the list wanting to take the exam or expressing interest. I doubt that all 100 will meet all of the requirements that you need for this first go around, but it looks like we'll have some number probably taking the exams in April. So a little background, 15 years ago in Arizona, we implemented a legal document preparers program. Now our program was actually broader in terms of what document preparers could do than the triple LPs up in Washington. We've had that program for 15 years. They have to be certified and licensed. We can take complaints and again can disbar them if they don't act properly. We have 700 of those, and that number has stayed fairly consistent over the years. It's built up to that and stayed there at about 700. Now I mention that because in order to renew your license every couple of years and pay those fees, you've got to be making enough income to do it. So they're out there working in a variety of areas, but they have very broad abilities to prepare documents for customers. They have not been allowed to go into court, although there's some loosening of that regulation right now where they could go to court, and if a judge asks a question for clarification, they're going to be allowed to do that. We get very few complaints about legal document preparers. We get almost no complaints from consumers. The complaints we do get are usually lawyers complaining that the document preparers done more than they're authorized to do. They've gone further. But their consumers, their customers, if you will, very, very few complaints. Arizona also is the court system that invented self-help centers. Came out of Maricopa County and spread through our state. You took those even to another level. You have self-help centers in your courts, have probably better funding than we do. But we've run sophisticated self-help centers for decades, and they play a role, and they're a good thing. But what we observe is even when you help people fill out forms and try to give them some information of how to proceed, many people just do not have the ability to go into court and articulate their case, particularly in a professional, unemotional manner. This is particularly true, and I see a lot of judges here. If you've been in family court, you know what I mean. It can be rather chaotic with pro se litigants, husband and wife, soon to be exes, in a battle over everything during a divorce. In Arizona, I'm sure like California, probably now 85% of people coming to our courts in divorce, family court matters, both pre-divorce and post-divorce, are not represented by attorneys. They've either chosen or they cannot afford an attorney. So this isn't a matter of getting an attorney for people. It's a matter of do they do it themselves or will they find something else that will be in between. The same thing started to become true in civil cases. Now, unlike you have one trial court system, we really have two. So we have our general jurisdiction court that handles cases, civil cases over $10,000 and felonies. And then we have a limited jurisdiction court system that handles misdemeanor cases and civil cases under 10,000. They also handle evictions and debt cases and small civil cases under 10,000. Many of those cases, majority now, are not represented by attorneys, at least on the, say, the defense side, the tenant, the debtor, or in a civil case. And I will remind you that the vast majority of civil suits in the United States are less than $10,000. So your dad, I'm sure, shows the same thing. It's probably about 7,500 or less is the most frequent lawsuit. We all hear about these big suits, and they're occasionally there, but that's not the majority of cases. So the big volume for us is in our limited jurisdiction courts. They also handle traffic matters. So we tried many things to help pro se litigants and to improve access to justice. Made some strides, but simply didn't move the needle enough. We've done pro bono emphasis. We even passed a tax credit law that allows a couple to donate $800 a year to a legal aid program, which we have many, and you get 100% of that donation back as a tax credit. And that's helped a little bit, but it still hasn't moved the needle enough. And so after working on this for many years, our court decided to go further and be more innovative and did two things, well, several things really, but the two that get the most attention is they abolished Rule 5.4 and allow for non-lawyer ownership and partnership with law firms that provide a lot of innovation and legal services. And what we're talking about today, they've authorized LPs, and I guess I'd put it, they're envisioned to be like a nurse practitioner is in the medical field. And we're going to launch that here, like say next month, will probably be the first group. There are really two ways to become an LP, one through experience and one through education.
Dave, I'm sorry, just because we have a number of presenters and I'm just hoping we have had some background on the Arizona program overall.
Sure. Why don't I just stop giving that background? I'll just stop and answer, let you ask questions.
Well, the background that I think we do want to hear about is the decision to allow the paraprofessional to represent parties in court. How did that come to pass? I think there was some relationship to your longstanding LDA program, and maybe just to talk a little bit about that. And then I see we have some hands up also.
Well, that's right. We already had done the document preparers, and that wasn't enough. And as we observed people going into court and not really being able to present their cases, it came up that we really need to provide sort of a nurse practitioner, and that's how the LPs came about. So when we went into this, that was on the task force's charge to consider allowing non-lawyers to represent people in court. Now we've had experience with that in other ways for years too, and I can mention that. But in fact, we had a Rule 31, and Rule 31 coincidentally had 31 exceptions where non-lawyers in various capacities could go into court. And that's been around for years. But it really came about from our task force saying we need to provide people with an alternative to a JD degree lawyer, and the belief that you don't need a 3-year JD degree to deal with every legal problem. You certainly need lawyers for many problems, like you need doctors for many problems. You don't go to a nurse practitioner for brain surgery, but you don't need a board certified doctor to give you a flu shot or to take your kid to see if he has strep throat. And so the philosophy here is we think we need to mimic more what's happened in the medical world, where there are different education, training, testing requirements for different kinds of folks, provide different types of legal services. So let me pause there and let you ask questions.
I don't know which Steve was first, but I'm going to take Steve Fleischman.
Hi, Mr. Byer, thank you very much for coming. I'll try to be direct and to the point. I looked at the Arizona program and I concluded that paraprofessionals are allowed to practice in 3 courts: your family law court, which includes civil harassment proceedings; municipal court, which appears to be mostly traffic and criminal; and your justice court, which has jurisdiction up to $10,000, which in California is small claims court.
Yeah.
Do I have that outlined basically correct?
Well, basically, but you missed one big category. They're also allowed to represent people in administrative hearings, of which there are thousands of thousands. So you've got special education, motor vehicle, workers' comp, and so on. They can represent them in those categories.
And we've already addressed administrative in another committee, so I don't want to go there.
Sure.
Within those categories, which basically are family, civil harassment, and small claims court, I just don't know Arizona procedure. Are there any jury trials involved in those 3 categories? In California, there would.
You could have jury trials in like a $10,000 lawsuit, sure.
Okay, and they would be allowed to do.
Or in a DUI case, misdemeanor case, and so forth. Yes, so the answer is yes, you could have a jury trial. They're not like you are jury. 98% of our cases are resolved without a jury anymore. So but yes, it could occur.
Because we heard from a professor, Rebecca Sandifer, who said no jury trials in any states that allow paraprofessionals. So I'm taking what you're saying, but that's where I was coming from, was Professor Sandifer's statement. If you're telling me there could be a jury trial in a small claims case, I take your word for it.
Yep, could happen.
Okay.
Well, and be clear,
California would not.
Just hold on one second, because I want to make sure that I understand. The trials could be, you mentioned small claims. I think you mentioned DUIs as well. Is that correct?
In theory, the LPs aren't allowed to represent someone who's facing jail time. And so in most DUIs, almost all, there would be jail time, so they probably wouldn't. But here's a phenomenon that happens in misdemeanor cases and in some DUIs. If the prosecutor waives jail as a sentencing outcome, then in our state, they're not eligible for a public defender to be appointed.
Understood.
And that happens a lot.
Got it.
And in part, the city courts and stuff, not the courts, but the prosecutors do it to save money for the cities. And so the LPs are envisioned to handle those cases. I don't think we're expecting them to do jury trials. And I'd have to, I guess in theory, it could occur, but I don't think that's the expectation.
I got it. Thank you.
And there's a right to jury trials in Arizona for cases below $10,000 in your justice courts?
Yes.
Okay, thank you.
Wait, Stephen.
There are 4 times as many jury trials in our limited jurisdiction courts than our general jurisdiction courts.
Okay. Are the Arizona LPs allowed to provide unlimited services in the area of family law, or are there restrictions on the types of matters they can assist clients with?
There's a couple of restrictions. One is
there's going to be the qualified domestic relations orders. I think that's consistent.
Yeah, the Quattros, although they can get certified in that. So we're going to put a certification and test in for non-lawyers to be able to get certified in that. So they could, but we haven't done that yet.
Okay.
So frankly, most of our lawyers don't do that. They go to a CPA or somebody who does that. But some of the CPAs are interested in getting certified and then becoming an LP. So that's one limit. The second is we have some limitation when you have a complex business situation. So like say a dentist, a doctor, where there's a firm and they're dividing that up. We don't let them at this point do those things. However, we are adding one thing. There's a petition before our court right now to allow LPs to come into felony initial appearances and appear for bail at initial appearances. I don't know how it is in California, but in Arizona, we do not have public defenders appointed at the initial appearance. And usually we don't even have a prosecutor. And so there's nobody arguing for, bail or release conditions for many, many people. So that's pending before our court. They haven't taken it up though yet.
Okay, and under the prior system with the LDAs where they were allowed to go to court, were they appearing in the family law matters and answering questions upon request of the judicial officers?
That's a new rule, so it's just getting started.
Okay,
Now, on occasion, they would go, they weren't really supposed to, but sometimes they were sitting in the back of the court and the judge could see a citizen floundering and they'd call the document preparer up. So it has occurred, but it wasn't really authorized, but it is now, and it'll be occurring more.
so the appearance of the non-attorneys at counsel table and making statements to the judicial officer is something other than these exceptions that you cited, is a new thing that will be happening in Arizona, both through the LP program as well as through the change on the limits on the LDAs. Is that
Yes.
accurate?
That's correct. And I should mention one other because it's going into effect right now. Our court also authorized lay domestic violence advocates. These are people that work in the domestic violence arena, usually with a shelter facility. And we have 2 programs being authorized. People have just passed their test and they're going also to be able to go into a court and provide legal assistance to a victim who's asking for an order of protection or something related to domestic violence. That's also starting right now.
Thank you. That was all my questions.
And I can mention some of those domestic violence advocates, again, have been going to court for years, sitting in the public area. But I know a lot of judges call them up to the table. They've been doing it for years. They help, they give comfort and answer questions. So we've actually just legitimized that and certified it.
All right, thank you so much, Dave. I really appreciate it. And as Justice Patru mentioned, if you can stick around, please do. And I think we will move on to our guest from Ontario. I'd like to start with Judge Krieger. She is able to. Great.
I will unmute.
Okay. Thank you, Judge Krieger.
You're very welcome. Just to give you a little background on me, the first thing I should say to Judge Rubin is we're in Ontario, Canada, and my thermostat is set at 66. So
Facing to Canada.
it's,
Judge Rubin is in San Diego, so he's a fragile flower. We understand.
so a little background on me. I've been a lawyer since 1985 in Ontario, and I became a deputy judge of the small claims court in 1996. So this is my 25th year at that. And in that capacity, I see paralegals all the time. A little background on paralegal regulation. Before regulation started, I think in 2007, there certainly were paralegals, but they were unregulated in Ontario. So since 1996, I've seen paralegals in my court at least 20% of the time at the beginning, and now more like 80% of the time. We're getting fewer and fewer self-represented litigants. I also served at the Law Society of Ontario for 4 years as what's called a bencher, a member of the board of directors. And in that capacity, you do discipline. So that's our discipline system. We have an independent tribunal for it, and we adjudicate independently. So I think that has a bearing on what Dave Byers was saying a few minutes ago. In Ontario, paralegals represent whoever they wish at our small claims court level. Our small claims court, however, has a jurisdiction up to $35,000. That might be 10,000 American dollars, but it's probably more like 30. So it's a $35,000 jurisdiction, but the paralegal can take the case from client intake right through to judgment. And they frequently do. I should note in there that in the time that I sat on the Law Society Tribunal as a bencher doing discipline, I don't believe I ever saw a complaint about a paralegal that had to do with representation in court. Many times it was sort of the breach of the more finicky regulations around advertising. There were issues initially, and this was years ago, back in, before 2010, there were some issues with respect to how to do the trust accounting and how to make sure that the books were all in order, that sort of thing. But that's a common complaint for lawyers as well, because they tend to hand the bookkeeping off. So paralegals in court, in fact, has been a great success in Ontario and has been a great success since 2007. As a deputy judge at small claims court, I was delighted to see paralegals because at least you had some chance of a person adequately identifying the issue and carrying the case through, focusing on that issue rather than on sort of personal feelings. And as Dave Byers said, that inability to articulate because they're emotionally involved. And I think it's been a great help too for litigants at the small claims court. Now, in addition to small claims, paralegals have jurisdiction in the criminal court, traffic, but up to and including now, I think, and Ms. Corsetti might correct me on this, she's probably better acquainted with some of this stuff than I am. There was a big kerfuffle over the jurisdiction in criminal court. Our federal government changed the severity of sentences in some cases from 6 months maximum to 2 years. Up until the change, paralegals have been able to represent anybody in a case that had a 6 month or less incarceral sentence. So when that change was made from 6 months to 2 years for these offenses that had previously been a 6 month maximum, there was a lot of work done to make sure that paralegals retained their jurisdiction over the offenses that had previously been a 6 month maximum. And I believe that that was successful, that paralegals retain that jurisdiction, even for offenses that now carry a maximum of 2 years, but previously carried a maximum of 6 months. Again, I don't recall ever getting a complaint, and we get very few paralegal complaints at the Law Society compared to lawyer complaints. But I don't recall ever seeing one that talked about a paralegal being incompetent to do a small claims trial, to do the criminal trials that they can do. That said, once the criminal or small claims trial is done, paralegals have no capacity to take an appeal from that trial. And that, I think, is simply because it goes to a different level of court with multiple judges, and the focus there is legal issues, right? And may involve complex sort of legal analysis that, as Dave Byers says, you might need a doctor for that. So that's something. Now, I should also say in small claims, we don't have any juries, so it's all easy peasy from that standpoint. What else do I want to say? Immigration is another area where paralegals have really found a niche. That is in some flux, and I'm sure Ms. Corsetti can tell you more about that, because I don't know how that discussion is panning out at the moment. I've been out of touch with it for a little while, and it's a complex discussion. Last but not least, certainly not least, is family law. And I'm going to leave that entirely to Ms. Corsetti, because that has been something that paralegals have worked for many years and have been working for capacity in that area. And it might finally be coming to fruition. The Law Society was talking about it. The whole 4 years I was at the Law Society, we were talking about it in various committees, and it looked like we were almost ready to take the first step. But Ms. Corsetti will be able to tell you more about that. All in all, paralegal representation has been a huge success in Ontario. It has opened up access to justice. People who were previously self-represented have been able to find somebody who probably charges a lower hourly rate than a lawyer does. And people who might otherwise have remained unrepresented in several, sort of traffic cases, criminal cases in that area have been able to get representation. And all in all, what's happened over the sort of 15 years or so that, and I noticed, yeah, Mr. Byers talked about the fact that, mostly it's lawyers complaining about paralegals. We have sort of reached the point now where paralegals have become a fact of life. Old folks like me are transitioning out of the practice of law and into sort of adjudication and that kind of thing. Young folks coming in, people who are being called this year, people who were called in the last 10 years, paralegals are simply part of the landscape. So with that, and I think what you'll find is that if there is conflict, it will recede over time as younger people move into the profession. So I'm going to leave it to Kathy Corsetti to tell you a bit more about paralegal qualifications and professional associations, that kind of thing. I know they can make firms because I know some very good paralegal firms, but I'm going to leave the rest of it to Ms. Corsetti. Thank you. Any questions?
Judge Krager, I don't see
any?
No, I don't see any hands up. Oh, I do.
I think maybe if we could,
Oh, sorry. There are.
no, that's fine. Go ahead.
Okay. There are several, actually. I was the first.
Well, I think the question was, I don't know whether people were thinking maybe we should hear, I know I said each person, but maybe from Ms. Corsetti as well. And then I don't know if there might be questions that it's best for them both to address. And so my suggestion would be that we hear from Ms. Corsetti and then we can take the questions, to the judge and Ms. Corsetti.
Okay. And Kathy, I know you're a fountain of information about the program overall, but if we could focus a little bit on the in-court representation piece, that would be great. And thank you, Kathy.
Thank you. And thank you very much for inviting me today. Obviously, I'm very interested in following different states and provinces and their advancement with paraprofessionals. We're called paralegals up in Ontario. So Ontario is the only province that has licensed paralegals, and we were licensed in 2008. I've been acting as what you would call a paralegal for 44 years now. So back then, our legislation allowed what was called agents to appear at court. And it was just the normal thing we did. It wasn't like we were trying to do unauthorized practice. We were allowed in the small claims court. We were allowed in the landlord and tenant board and traffic court. So then when we got regulated in 2008, the Law Society thought that maybe there would be about 600 or 800 people to license. I think there was over 3,000 paralegals that came forward. I've been a bencher, like Ms. Krieger, I've been a bencher for 11 years now. I was first elected in 2010. And as Ms. Krieger had indicated, a bencher is on the board of directors of the Law Society of Ontario. So we always had advocacy. So to me, to look at this type of a position without advocacy, it just doesn't make sense to me. I don't see how that's providing access to justice. I know myself personally, when I went to a small claims court, and I was petrified, and I do this for a living. So, I mean, we're there to assist the person, make them feel calm. And obviously we know we have the case law, we have the experience. We're in courts basically where not very many lawyers attend, being landlord and tenant and small claims court. Traffic and administrative tribunals. There's probably 100 administrative tribunals in Ontario, and that's what the paralegal scope is. We're currently working on a family law license for paralegals. It's been a long process. I'm actually chair of Access to Justice at the Law Society of Ontario, and I'm also chair of the Family Law Working Group. and we've been working and working and working on it. We do have a limited scope. Advocacy is definitely part of it. Otherwise, we feel like doing the paperwork and putting someone at the door and kind of pushing them through is a disadvantage to the person who needs representation. And I assume most people need representation. In Ontario, I think we're up to about 80% of self-reps in family law. We see this as an access to justice issue. I don't understand why advocacy is an issue, because ultimately the judge is there to make the decision. I mean, the advocate can only help, whether it's a lawyer or a paraprofessional, can only help their client, in my opinion anyway. Sorry if everyone doesn't agree with me, but that's how we've always known it. So to be without advocacy, I find that to be a real disadvantage, and I question how successful that would be. And I do know preparing legal documents is a huge help, but then what? You know, if they don't understand the document, I mean, a lot of people, obviously English might be a second language. You know, a lot of people don't understand. We know what the forms mean, but for someone who's a layperson, they have no idea what those forms are, and need representation when they're most needed before the court, where they're maybe being questioned or by the other side, and you know, what have you. We are insured. We have our code of conduct, like the same as the lawyers. We have discipline, as Ms. Krieger indicated. We have to have continuing education. And, you know, as I said, the ultimate, there's the judge there for consideration. So I think any judge would feel it would be helpful to have a professional in front of them that can give assistance better than a self-rep, in my opinion. I don't know if there's anything else that anyone wants to know about. I practice in landlord and tenant court. I used to do small claims over the years, but right now solely my firm does landlord and tenant. And again, the jurisdiction is up to 35,000. As Ms. Krieger said, 10,000 American. But, you know, and there's been no issue with advocacy being a problem with representation, that the paralegals aren't qualified. And if they are not qualified, then they get a complaint, and that goes into discipline, and they can lose their license. Oh, that's the other thing I want to indicate. So the education that is mandated for a paralegal is a 2-year college program, plus they then have to do placement, like articling. I'm not sure if that's what it's called down in California or Arizona. And then they have to write an exam that the Law Society prepares. So they have to get licensed with the Law Society. Even if they graduate from their college, that doesn't give them the license to write another exam through the Law Society. The Law Society of Ontario dictates to the colleges what the education is going to be, what the competencies are. And you know, which is different than the law schools. The Law Society doesn't dictate to the law schools what the competencies are. But, you know, so the paralegals are trained, they come out graduating, knowing the law, knowing how to advocate for someone, and knowing their obligations and their rules of conduct that they have to comply with through the Law Society. So thank you. If anyone has any questions, I'm happy to answer.
So before, thank you very much. Before we jump into questions, I just want a point of clarification so everyone knows 35,000 Canadian dollars is 28,000 US dollars.
Goodness, I was going to share that.
I just checked it up. I was like, what is it today? It's point, so it's 28,000.
So we've got Stephen Hamilton.
Thank you. So Ms. Corsetti, I wanted to just confirm. So the discussions are still ongoing about having the Ontario paralegals assist in family law matters, true?
Yes.
Okay. And I don't know if you can back up what the research I did. So I looked at the 2019 annual reported data. Right now, there's about a 10-to-1 ratio of attorneys to paralegals. I had it at 37,900 lawyers versus 3,700 paralegals. Does that sound accurate?
The number does fluctuate because of, even with lawyers, like I would have said, your ratio is correct, but I would have said it maybe was more like 50,000 lawyers and 8,000 or 9,000 paralegals. So
Yeah. The last report I can see was 2019. What I thought was interesting was of the new licensees, 23 were attorneys, 2,423, 1,057 were paralegals. So you're getting almost as many, half as many new licensees are your paralegals, correct?
yes, and,
Okay.
and the market's a bit flooded. But
So-
as Ms. Krieger said, the difference I've seen is now law firms are hiring paralegals.
I have suggested that may be part of what happens as a result of our program. Okay. Can you clarify me? So I understand you don't have the family law program in place yet, but what are you expecting in terms of either units or time period? How much education do you think is going to be requested of these family law paralegals in Ontario before they can make an appearance in court? And then my second question related to that is, how much either practical training or experiential hours are you expecting them to have with a mentor, a lawyer, or a public service group before they're allowed to actually make in-court appearances?
Well, I mean, that's a really good question. I'm trying to see if I have the education component in my trusty little family law binder here, but it is also all confidential still because it's in camera. But there was a submission that was just sent out to the public, to lawyers, to paralegals regarding the scope that's being suggested and what the competencies are. And I think it's something like 1 year of, if you're a licensed paralegal, the college program would be or university, whoever's deciding to teach it, would be a 1 year program. We haven't gotten into whether there will be a placement. The problem, honestly, is, this is the first time the scope's being expanded for paralegals since 2008. And I'd be lying if I said it was popular with the lawyers of the province. Some are in favor, but a lot are a little nervous, obviously. We're not sure that if these FLSPs, as we're calling them, would even get placement, which could be a problem.
Just to expand on that a bit, if I could, Stephen. One of the reasons it's been so difficult to sort out a paralegal scope in family law is that the court system for family law in Ontario is extraordinarily confused. The Superior Court of Ontario has jurisdiction over some things. The Ontario Court of Justice has jurisdiction over some things. And then the Unified Family Court has jurisdiction over all things. So part of the problem has been sorting out what to put in the paralegal scope and what not to put in the paralegal scope. The difficulty is that the really tricky parts, like access and custody of children, are in the parts where you would normally expand paralegal scope. So that was an almost insurmountable barrier.
Can I ask both of you then? I understand your family law program is not even nascent, it's still being formulated, and some of the information you can't share. We have gotten to a point where we have very specific tasks, and they're very expansive, that we're going to propose for family law paraprofessionals in California. And I guess what I'm wondering is, are you, either of you, anticipating there will be restrictions on the scope of services that the family law paralegal could provide in Ontario when they're allowed to do in-court advocacy?
So if I can switch that question just slightly, because, since the focus of our conversation today is in-court representation. So I think what you asked, or maybe it's because it's what I wanted to ask, is, presuming that they're allowed to do things within the family law scope, would you anticipate that there would be a restriction on those, on the scope in regards to in-court representation?
So there definitely is a limited scope, and but there definitely is an advocacy component. For example, uncontested divorces, maybe. I'm not sure if you have restraining orders, if that's your family.
Sure.
Yeah, so that's where we're feeling that FLSP would be helpful. Like I said, this is all just up in the air still, but I think I could send to you what the scope is proposed, because it went out for consultation, a public consultation, and also what the competencies are. You know, I don't do family law. I'm
Oh, that's
not an expert to tell you what advocacy is allowed. I know what it says, but I don't know what it means. I'm sorry, but I could
No.
send you what we have as scope, and that would probably clarify a lot of that.
But that's posted on the web, isn't it, Kathy?
I believe it is. It
Yeah,
has.
so I might send along the link to Leah, and I'm sure she'll share it with everyone.
Yeah, yeah. I'm happy to
Thank
do
you.
You know, let me add 2 points to that. In Arizona, I suspect the same as in California. 50% of all our in-court activity in family court is post-decree. And the vast majority are not complicated legal issues. There are arguments over implementation of the parenting plan, who's paying for the Nike, the baseball. There are arguments that take a lot of time, but they're not complex legal issues. Also in England, the UK has never regulated any of the family law practice. That's the other extreme. There's no regulation. Anybody can practice a family court and family law over in the UK.
I think prior to regulation, you could attend at family court with the judge's permission as an agent, which is what was called. But once regulation came in, you weren't allowed to go to family law, family courts. I know there was some, like for example, disbarred lawyers, and that had a big practice and were allowed to do that.
That's helpful. Thank you. And I don't mean to cut you off. I'm seeing, like I can see that Ira's had his hand up for a while now. So I just want to make sure we have a chance for people to ask their questions. Ira?
Uh-oh.
Ira, you
Ira,
have
we
to-
can't.
yeah, okay.
Are there any cases, types of cases where the paralegal can handle a jury trial? I did hear that Judge Krieger say that there's no juries in the small claims court, but I wanted to make sure we're covering all bases. For instance, the 2-year crimes, misdemeanors, whatever they are, no juries there?
Nope, not at that level.
Okay.
Right, the juries are saved for indictable offenses.
Are there any cases where a paralegal advocates?
Not that I know of, and I never practiced family law either, but I have not heard any one of my friends who practice family law say to me, yeah, I had a jury trial. I'm thinking they don't have jury trials in the family court.
Okay.
It's either that or nobody ever asked for one.
Only in Texas.
Yeah.
Oh, yeah.
California, they do have the custody trials are by jury in Texas.
My second question is this, just clarifying a term, mainly that Kathy Corsetti used, advocacy. By that term, you mean in court, in person, as opposed to simply filing briefs or motions? I mean, writing briefs or motions?
Like, okay, so I mean, right now it's not in person, it's all done by Microsoft Teams or Zoom, but paralegals like myself basically are in court every day. Like I do landlord and tenant, but even the small claims court or the traffic and criminal, that's what we do. There's not like, I'm not sure in landlord and tenant in California, but there's not a lot of paperwork. You know, you fill out a form, file it, and the advocacy comes when you appear before, we call our judges and LTB members. So when you appear before the member, and Ms. Krieger could tell you the same about small claims court. I mean,
It's essentially lawyer light.
Yeah.
Right.
Lawyer
Take
light.
it from soup to nuts. Yeah.
So we're clear, and I appreciate the term advocacy because obviously that's what's happening when you both have used the term advocacy. It's encompassing, as Ira noted, anything that would need to happen in the courtroom, and I'm including on Zoom being is in the courtroom.
Yes.
We do full trials, absolutely. Case law submissions, cross-examination, calling witnesses, absolutely. That's what we're trained to do.
Thank you.
Okay, so Carolyn's had her hand up, and then Kim, and then I would love to hear from our client.
I've been going back and forth and going back and forth. I'm from Detroit, so I haven't heard the word kerfluffle in a long time. Oh, but yeah, I just had with regard to the issue of due process and representation. I think you mentioned some things about there you go. Some areas where there was a concern in your courts about representation with a lawyer versus a non-lawyer. How can you elaborate more on that? And is that only in the criminal area, or are there constitutional issues in Canada about civil areas, chancery, equity?
It's not particularly a due process thing. The way it seems to have shaken down, and largely this was driven by the Law Society when they enacted regulation, right? Kathy mentioned that before regulation, there were disbarred lawyers who would appear as agents, right? So the, I think partly to get around that, the Law Society started to regulate paralegals. So far, so good. However, it appears to me, and I mean, I wasn't there to do it, but it appears to me that the consideration was almost the greater the peril, the more need for a lawyer. So for example, a paralegal could appear in court for an offense up to 6-month maximum sentence, but not up to 2 years and beyond, right? So in that sense, the greater the peril, the more it required a lawyer. Likewise, with the free representation and ability to appear in court at small claims, but no ability to take the appeal and no ability to appear at the Superior Court in other capacities. Small claims here is a branch of the Superior Court. So, but no ability to appear at the Superior Court beyond that. So to me, it sort of came down to, look, the greater the peril the individual is in, the more likely it is going to be beyond paralegal scope. We don't really have, we call it the charter. We don't really have a lot of charter issues arising out of that kind of thing, or due process issues. It was sort of a practical decision, I think, by the Law Society when they created the Standing Committee for Paralegals.
And nothing really changed once we were regulated. We were already in those courts, and able to be in those courts doing representation. So we have full scope in landlord and tenant, full scope in small claims. Criminal court is where our scope is limited, and also immigration. Immigration, I know Janice, Ms. Krigers touched on it. So the only thing, or the only scope a paralegal has for immigration is before the IRB, which is the Immigration Review Board, which is the appeal board. We're not allowed to do full scope. We have to have become an immigration consultant, which is a federal regulation. That's in a whole nother story. There's our bylaw 4 does not allow us to do anything more than that. And there is some controversy, some litigation actually again about that. But otherwise, paralegals, where we are, most lawyers don't go. And I have lots of clients who are lawyers who refer me their clients because they don't want to go to those courts. You know, I mean, to spend a day in court for under $10,000, I think probably anyone's fee would be pretty close to that, right? So, you know, that's why. You know, the paralegals are so successful in Ontario.
But there are courts where I mean, I think it's pretty clear you said there are courts, there are places where full scope representation is not allowed.
Correct.
Right. Like anything over 35,000 has to be sued in a higher court where we're not allowed to go. We go to what's called a small claims court. It's its own court, right?
Okay, we've got Kim and then Julia.
Thank you for all this information. I just have a question for Judge Krieger. In your earlier comments, you were talking about how when it first started, you saw about 20% of the time paralegals coming in, and now it's about 80%. Are you seeing less attorney representation, which is the change, or is it really due to non-represented individuals now having representation?
There's been a peculiar swing because the monetary jurisdiction has risen. The monetary jurisdiction of the small claims court has risen over the past 10 to 15 years from 6,000 to 35,000. So this has encouraged some lawyers to tread carefully into the small claims court. So some lawyers now come, not many. The majority of representatives I see are paralegals. I see a lot more paralegals than I used to, which means unlike family court, my interaction with self-represented litigants is dropping, and my interaction with represented litigants is rising, whether by paralegal or by lawyer. Before paralegal regulation and before the jurisdiction went up to $35,000, we almost never saw lawyers. I mean, we see them rarely now, but we almost never saw them. The only time you would see a lawyer is if it were somebody in their first or second year of practice who wanted to go through the mechanics of running a trial. So they'd come to small claims and, you know, less peril, right? They'd come to small claims and you'd run them through all the things you have to do to put your case in, right? As a form of mentoring.
Julia, and then Judge Rubin, and then I do think we need to go to our client presenters. So go ahead, Julia.
Thank you very much for coming today. So you say that you have not received many complaints about the paralegals, and that if you do, you hear about it perhaps from only attorneys. Am I understanding that correctly?
At the beginning, right, I think there was sort of between say 2007 to 2012 or so, the relationship between lawyers and paralegals was very contentious. Kathy might say to me, yeah, it still is, but I think it's changed. I think the point I was trying to make was that per capita, the Law Society, the complaints I saw and the scope of the complaints I saw, the Law Society actually receives fewer complaints about paralegals than they do about lawyers per capita, right? So I think that's an important point. It means paralegals are working hard to make sure that they are on side all of the myriad regulations, rules, regulations, bylaws, record keeping requirements that our Law Society has. That's not an easy task. The other factor to that is that as we proceed, right? Yes, I think in the beginning, lawyers would complain about paralegal advertising, for example. That's where you see some of the complaints. Or they complain about paralegal, I don't know what, but the ones I saw mainly were like advertising and record keeping things. I never saw a complaint about, oh, this paralegal went to court for me and did a really bad job. He or she is incompetent. Because I do think that the competencies are well established by the education and the 7-hour exam they have to write from the Law Society.
So,
Ms. Corsetti, do you have anything to contribute?
yes, thank you. I am on a committee at the Law Society called it's called PAC, so whatever it stands for. But so I see
Authorization Committee.
That's it. I see every single case, every single complaint, lawyers and paralegals, and then we decide where it's going to go. And I agree with, not that I've ever thought of this before, but I never have heard someone did a bad job as a paralegal. Sometimes they don't show up in court, and there's a complaint because of that, you know, because people do run off the edge, you know, and have some other issues going on. A lot of the complaints come through the spot audit committee because the Law Society does audits on paralegals and lawyers, and their record keeping wasn't up to date, and they haven't, you know, complied with the request from the Law Society, but not because of the advocacy, not because of, you know, not knowing what they're doing. I mean, that doesn't come before me. Not saying it doesn't happen, but it doesn't come before me. And I think also, if you look at our scope, we're not talking about estates where there's $1 million taken from the estate funds, you know, sort of thing where, you know, gets people more into trouble, which are is outside the paralegal scope. A pretty limited scope, pretty limited issues at risk.
So what so that I'm clear about what you just said, so you have not seen in the entire time that you've been part of the family losses or the Law Society, any complaint about a paralegal due to their as a result of their representation in court?
Correct.
No, but you know, to be fair, you don't see that many about lawyers either. You see that they don't show up. You see that they maybe took money and shouldn't have, and that sort of. No, not because of their behavior. No, no.
So do you see those kind of complaints against attorneys? I think we would say that perhaps in California, maybe there's just more complaining.
I'm trying to think. Jen has helped me out here. I mean,
yeah, what you'll see, I mean, you will certainly hear complaints about competence, right? Because there's failure to serve the client as a complaint. Now, I haven't seen that leveled against a paralegal, right? Failure to serve the client. I have seen it leveled against lawyers, right? And you might be right, Kathy. I mean, where there's sort of more at stake, people get more exercised, and you look for different, you know, different things to quote charge,
I mean,
for lack of a better word.
There are paralegals who have not shown up in court and
Absolutely.
and complaint put against them. So, I mean, but it's not because they showed up in court and did an awful job.
Yeah, exactly.
They didn't show up at all. And, you know, guilty plea entered again, or sorry, a guilty charge and entered.
Yeah, somebody was convicted when they shouldn't have been. Yeah.
Yeah, and because they definitely, you see those, and a lot of times, whether
not
it's mental health or addiction or something has happened in the paralegal and lawyer's life, and that's what happens.
Thank you very much.
Thank you.
Carolyn, I see your hand up. But
super quick. Are there, Ms. Corsetti and Judge Krieger, are there any statistics on that? I know the state for California publishes that, either legal malpractice suits or disciplinary complaints.
If you, I'll send you the link for the Law Society Tribunal because I believe they keep the statistics. Now, they might be confidential. I might have seen them in my capacity as a bencher. But at the Law Society Tribunal, they usually have statistics on ongoing cases, how many are resolved, that kind of thing.
Thanks.
We do have the annual report from the Law Society that does have some of this data that we can share, that I do know is public. Okay. Thank you so much. This is great having you.
You're very welcome. Thank you for inviting us.
Yeah, thank you. And if there's anything that comes up, feel free to send me an email and I'm happy to address anything. And like I said, once COVID's over, if you need us to come down.
Yeah.
I think we all want to come up, but we can negotiate.
Well, maybe, but the weather's nicer down there, I think.
Yeah, the other thing is that, I'm going to leave now because it's lunchtime and it's still 66 degrees in here.
All right. Bye. Thank you.
I'll pass on that trip to Ontario for now.
Ontario's pretty nice.
So we have 3 clients, one client of a triple LT from Washington, and then 2 LDA clients. And I think what we'll do is start with Christina, so a client from Washington, and then move to Dana, and then close out with Michelle. So Christina, are you available? And thanks for hanging in there. Okay, wonderful, great. So Christina, if you could just share briefly, you know, if you're comfortable, why you hired your triple LT, and then some of your experiences with whatever was allowed with respect to the in-court representation for you.
Okay, I'm Christina. I'm up in Washington, or down in Washington, depending on where you guys are. And I was trying to get third-party non-parental custody of my niece and nephew. And I went to my local court and they were like, go get these forms and just fill them out. and I took them home and looked at them and didn't have any idea what I was doing. And, you know, I have a college degree. I think I'm pretty smart. No idea. I don't know anything about this. And so I started trying to see how much a lawyer would cost, and the kids were already with me. So I already, you know, am taking care of the kids. They're 13 and 7. So I didn't have money for an attorney is what I'm quickly figuring out. And this is a really big deal. I mean, I don't want to mess this up. So I just started trying to figure out how to find help, and somewhere I found the triple LTs, and I worked with a couple up here, and my first appointment with them was amazing. They told me the prices, and it was still more than I had, so I had to go apply for a loan, but it was significantly cheaper than an attorney. And they were able, here in Washington State, they couldn't speak for me at the time, but they could do as much as they could before the adequate cause hearing. So their goal was to get everything done within that time. So if we got adequate cause, and I did have to get an attorney to help me the rest of the way, the cost would be significantly cheaper because they had prepared everything. And having them was a humongous weight lift off my shoulder. I would have loved if they could have spoken, because it was really intimidating, one, being there in court with the judge, and also in my position where I'm trying to get non-parental custody of the kids, you know, their parents are on the other side. So there's, you know, hurt feelings and hostility. And so you're dealing with a lot of things. Like you're scared because you're going to talk and you don't want to screw this up. There's people who aren't happy with you on the other side. Yes, it would have been so much nicer if they could have spoken for me. But having them be able to stand up there with me at minimum was amazing. So I didn't feel like I was alone. So often in these types of situations, you feel like the bad guy, especially from the parents of the children, because you are doing this. And so it's just so emotional, and it's a lot. It's a lot. So I can't speak my praises enough for our triple LTs here. I tell everybody to go and see if they can get one, because I don't know what I would have done if I hadn't gotten them. I don't know what I would have done. And because of them, I was able to get temporary custody. They found adequate cause. And then I did have to hire an attorney, but I only needed him for very limited. Like, I spent less than $1,000 on an attorney because they had done so much of the work. And I was given permanent custody in November, and that just wouldn't have happened without them. I don't know what I would have done. So that's been my experience.
Thank you so much, Christina. We've got a couple hands up, Sharon and then Fariba.
Thank you. And thank you so much for being here today. I am just curious to know whether or not you sought out legal aid or free legal assistance before you found the paraprofessionals.
So in Washington State, it's 211. I don't know if that's all over the US, but you call and they can provide you with resources that can help you. And unfortunately, I made too much for certain assistance. And then there was a program that would cover your costs for free, but they weren't taking anybody. They were like, it was a voice recording and it said, we're currently not taking any new clients, try back in like the beginning of the year. And so I just didn't have time. Like, I had to get this started quickly because I was worried that their parents would come and take them, which they have the right to do at that point. So.
Thank you.
Fariba.
My question is similar. Good morning, Christina. Thank you so much for being here and sharing your story. So just to confirm, and I should look this up myself, but I'm going to ask you since you're here. So you tried to, or is there a self-help program in Washington courts that have form packets, samples, staff to review your forms and answer your questions?
Yes. So you can, there is a place in the courthouse. They'll give you the packets. There's like some YouTube videos online, and they said once you filled out the form, you could come back for a 30-minute like meeting with one of their people to go over it with you. But that was it. I didn't know how to fill out the form at all.
And you didn't find that too helpful? The half an hour one-on-one wasn't
I didn't find it helpful at all.
Okay. And you prefer to pay for the additional one-on-one in-person assistance that the triple LTs could provide?
Yes, I do prefer that. And I was really glad I did, because I mean, there's a lot of stuff that they did that I wouldn't have necessarily known. And I'm in kinship groups that have other kinship care providers. And I know some of them who have done it on their own. It's taken them a few years to get it done, versus I officially started with them December of 2019. And by November of 2020, I had permanent custody, which there also was some lag because COVID had happened and courts were not knowing how to submit paperwork to the attorney and things like that. But my process was really fast, it seems like, since I got their help versus doing it on my own.
Okay, and one last question. You don't have to answer this. I heard you say you ended up having to hire an attorney for something. Would you be willing to share why you had to do that? You don't have to, just asking.
So at the adequate cause, my triple LTs had told me, we can get you up to adequate cause. At that point, we can give you some referrals to attorneys that have worked with us that do sliding scale if you need to go further. And so I got an attorney because, well, one, we weren't sure. Their mom would show up at the court hearing. She wouldn't file a response, but she would show up. And so we didn't know, I mean, would they contest, like, how was this going to play out as we went further? And I honestly, it was a lot of stress alone, just all of a sudden having 2 children. Like, now I have 2 kids to care for. And for me, I was like, I can't take this on too. This is just too much. I would prefer, and at that point with the sliding scale and the fact that the triple LTs had done so much, the cost for the attorney to kind of finish it out was just such a burden off my shoulders. I remember talking to him and him saying, okay, so I'm going to submit this. So prior to the attorney with the triple LTs, I'm still the person getting stuff. I still have to, like, I'm still a part of the process more. And when the attorney stepped in, all of a sudden I didn't have to even show up at court. Like, the attorney could be there. And just having that was such a burden off of my shoulders. It was worth I think it ended up only having to pay $700. Like, it was significantly cheaper.
So the combination worked for you?
It worked for me.
Yeah. Well, thank you. And as I say this to every guardian, the kids are lucky to have you. Thank you, Christina.
Thank you.
Right, Judge Wiley.
So Fariba stole it. I was going to say, Christina, thank you so much for coming and talking to us. I'm glad everything worked out. And more importantly, thank you for stepping up for your niece and nephew.
Thank you.
Thank you. Great. Thank you so much, Christina. Appreciate it. I think we are ready to hear from Dana. We're moving on back to California.
Hello. Hi.
Hi.
Sorry, I had some technical difficulties with my laptop, so I'm on my iPhone. I just kind of wanted to say my experiences were from years ago. I had a divorce attorney who I paid $8,000 to. Long story short, during my divorce, my ex-husband was excluded as being my daughter's father. So I filed I petitioned the court for paternity for the alleged father. Again, the attorney came back to me and said it was going to be $3,000, which I did not have. So I found my LDA, who was a godsend. She basically explained the whole court process to me, the documentations I need, and she really empowered me and, to find my voice, to use my brain, to educate myself. I spent countless hours at the law library. And the difficulty was, when we did get responses back, it was kind of conclusive presumption. So I knew I was in for a battle. That and the alleged father's dad was a well-known judge. And yeah, so it was a difficult case. She stuck through it all the way. At the end, I prevailed. I think without her, I would have been lost. I would have wasted the court's time. And the whole process would have been so confusing. So with paraprofessionals, I feel it would be really helpful, if she was able to be there and stand by my side and answer questions and, make sense of what I was reading in the library at times where I read and reread and reread because it just didn't make sense. The law is really not written for people, that haven't gone to law school. And, you read it and you're going, well, that doesn't make any sense. So yeah, it was difficult. And I'm all for paraprofessionals. I wholeheartedly believe, attorneys are wonderful. There is a time and a place, like Dave Beyer said, there's, when you need representation, if you're facing criminal charges or you're going to lose real property or assets or do time, definitely an attorney, that knows the ins and outs of the law would be helpful. So I'm all in favor of having paraprofessionals, just for the sake of justice.
Thanks, Dina. I know you spoke with Linda, not me. So I don't know, Linda, if you have any follow-up questions. I just would want to prompt you to talk a little bit about your experience in court.
In court for myself?
Yeah, so Linda, maybe you can help prompt because I didn't talk to Dana before.
Oh, okay. I'm sorry.
Yeah, Dana, and we did talk about the question about whether it would have been beneficial to have the paraprofessional, if the LDA could have actually represented and spoken for you in court.
Oh yeah, absolutely. It would have been extremely helpful, as, the person that just spoke before me, it was intimidating. And the response, they were going literally for my jugular. They threw case law, they threw everything they can at me, where even the judges were, or the judge actually was questioning, the respondent's attorney going, well, what are you talking about? So yeah, it would have been helpful to have a paraprofessional, a non-lawyer, stand right by me and you guide me through what I needed to do next, or even just calm me and say, listen, this is where, this is how we're going to do it. And if she could stand up and speak for me when I lost my voice, when I did not know what the correct answer was, what the correct protocol was, it would have been extremely beneficial. So I don't know if that answers your question.
Yeah, no, I just wanted to make sure you talked directly to that issue. And I see
okay.
Sharon has her hand up. Go ahead, Sharon.
Thank you so much. I have a similar question as I asked the other speaker. Did you seek out legal aid, or did you go to a self-help center before you found your LLT?
Honestly, I did not. I went straight from my divorce attorney to finding the person I used. And the reason for that, it wasn't accessible. And as the other speaker was just saying, you only get limited time. They push things so far out. And I feel personally that using the person I used, she was there anytime I called her. She did, every time I would get a response, she was always right there to, do the documentation. And I just felt it was more beneficial to me as far as, because I guess I'm impatient that, I wanted things done, today and not a week from today. Because it was very nerve wracking, and, no one was going to fight my case more than I fought my case. So, I studied, like I said, I studied the law. She directed me to websites and law libraries. And, although she could not advise me, which would have been extremely helpful if she could have advised me and been there. So,
had you had the choice of an affordable attorney option who could have seen your case the entire way through, including in court representation, would you have gone for that option instead of an LLLT?
I'm thinking about that. At this point, I don't think so. I just feel that I knew I can do this on my own. I'm intelligent enough to do it on my own, and I was. And so, no, I don't think I would have had that kind of representation. Just not knowing who I would, I guess it's kind of like a public defender, maybe. You just don't know who you're going to get and if they're going to fight for you and how much they're going to fight for you. So yeah, no, I was very comfortable in my decision.
Thank you.
Sure.
Okay. Thank you very much, Dana. And last but not least, we've got Michelle.
Hi, good morning. So no one's really touched on this. I'm actually, I went through a co-conservatorship for my brother. In 2019, he had a hemorrhagic stroke, which was life-threatening and very life-altering now that he's survived it. While we were going through all this as a family, we were asked questions of, did he have assets? Did he have life insurance? Who was responsible, to make decisions? We kind of were faced with not really knowing what to do. After talking to colleagues and friends that had gone through similar situations, they had, suggested to look into getting a conservatorship for my brother so he didn't fall into a, public guardian, so we can make the proper decisions for my brother's health and situation. I knew that we couldn't most likely afford a lawyer, so we attempted to go through the San Francisco self-help department. I took a day off and went out there to try and see if I can get some assistance. And at the time they said they didn't have a person to actually help with conservatorship. So I then ended up trying to go through the Lawyer Referral and Information Bar Association, which you kind of pay a fee to be, to get someone that could take your case, that you can consult with. So they grouped me with a lawyer, and he asked questions in terms of if my brother had a bank account or if he had assets and whatnot. After I had told him what had happened with my brother and we were trying to get, which was conservatorship, he said that there was nothing there for him to do and that he would not be able to take our case. So a little desperate to still try and make something happen, I actually tried Googling and trying to find some kind of legal representation. Actually think about taking out a loan on our home and see if maybe we can get somebody to represent us. But to our surprise, the hourly rate for a lawyer is very high. And I know, as my mom being a senior and retired and not much income, we may not be able to actually hire a lawyer. So therefore, I got back on the internet and found a self-help person that actually helped facilitate the documents, which was a great, great help. I would have loved for her to have been able to give us some legal advice. But I decided to actually, since she couldn't, after I had filed all the forms and had the court dates, I decided to take a day off and go to the courts and kind of sit through it and see what the conservatorship court was about. And I tried to empower myself to realize that I could be up there and answer the questions that the judge was asking the lawyers in the case that I sat through. But there are still questions, and we had questions and we still have some questions, but we know that we can't really ask the self-help person that helped us with the documents. Had we had somebody there, it would have been so great. One, you can even hear the trembling in my voice now because it's like reliving the whole thing over. And like Judge Beyer and Cringer said, sometimes the family's so emotional. You guys don't need that. But it would have been nice to have somebody to kind of show up for you and kind of be that sense of comfort to get you through this process.
Thank you so much, Michelle. And I just want to clarify for everyone, it was a little confusing, perhaps, but our first client speaker, Christina, was a client of a triple LT in Washington State. And then Dana and Michelle, clients of a legal document assistant here in California. So just wanted to make sure that was clear. And thank you, Michelle, really appreciate it. Does anyone have any follow-up questions for Michelle? No, looks like no. Thank you. I know you're a little nervous. You did a great job. All right.
Oh, so let me jump in there. If you were nervous, Michelle, you were super clear and super cogent and super helpful. So thank you again for being willing to share your story with us this morning. I think it's really important for all of us to be able to take a step back and look at all of this through the lens of the folks who need and would be using the potential services. So really, thank you again.
Yeah, I do have a quick question. Hearing from Judge Beyer and Judge Cringer talking about the type of cases that the paraprofessionals are going to be taking on or are taking on, immigration, some immigration, I believe family law, criminal, but there was no touch on conservatorship. Is that something that is being also looked into for the San Francisco, California paraprofessionals that they could take on?
We're looking at a lot of different areas, including that there have been some preliminary recommendations made. At this point, things continue to be under consideration, both short-term and long-term. We anticipate that the program is going to come out, presuming it's approved and goes forward, in a phased manner such that everything is not happening at the front end while everyone's getting their kind of feet under them. But we certainly appreciate the situation that you and your family found yourself in. And so it was helpful to hear from you. Thank you.
Thank you. Thank you for your time.
Thank you. And then I think next up we have Professor Moore. I had asked some working group members to send in any kind of UPL or ethics questions in advance. I believe we only got one, which I did forward to Professor Moore. That was from Ira. So I don't know, Professor Moore, if you're prepared to just respond to Ira's question or generally weigh in on whether or not the working group should take into account any particular ethics rules vis-a-vis the discussion about in-court representation or in-court advocacy.
Okay, I'll be happy to address that. Just by way of background, Ira knows me. We've known each other for almost 25 years. We joined the State Bar Ethics Committee together. So we've been in touch from time to time, but I was on the State Bar Ethics Committee. I joined in 1998. I ended up becoming chair of the Ethics Committee. For more years than I care to remember, I worked with the Special Rules Revision Commission that revised the California Rules of Professional Conduct. Those of you who might not like the new rules because they follow the ABA model rules to some extent, my apologies, but that was the charge that we got from the Supreme Court. I've also been involved with the ADLS task force. I was a member of the ADLS task force, and I'm currently a member of the Closing the Justice Gap. I'm guess I'm a part of those, not because I'm good at looking at the big picture, but because I get down into the dirty details and look at the rules, look at the statutes and so forth. What I focused on primarily, because that was my understanding of what the charge was, is there anything in the statutes? Because unlike every other jurisdiction in the country, California has this dual system of regulation where it's both the legislature has input and the Supreme Court has input. So sometimes you have to take a look and see, are there any problems that might arise by statutes that are out there? And there are a couple of general areas. First off, the focus is on, I was asked to look at the unauthorized practice of law or unlawful practice of law. And the approach that California takes, unlike some jurisdictions, for example, Utah, that actually defines the practice of law, we don't define the practice of law by statute, but we identify certain areas that are not the unlawful or unauthorized practice of law. We carve out certain exceptions, but we never get around to actually defining the practice of law in a statute. It's a fairly complex area as to what constitutes the practice of law. Some things that lawyers do, when the lawyers are doing it, would be the practice of law, where they might not be the practice of law if a layperson was doing it or an accountant was doing it. At any rate, what are the areas? The key provision in the Business and Professions Code is 6125. And 6125 provides that no person shall practice law in California unless the person is an active licensee of the state bar. Now, I think when you're talking about active licensee of the state bar, the change was made recently, effective in 2019, because prior to the split of the state bar into its disciplinary and regulatory function and its trade association function, the language that was used was member of the state bar, which referred to a lawyer. The licensees are defined in the Business and Professions Code in section 6002. It's all persons admitted and licensed to practice law in the state, except justices and judges of courts of record during their continuation in office. And then there's a subsection there that refers to when you see, should you see anywhere in the statutes, if we missed it, member of the state bar, it shall be deemed to refer to licensee of the state bar. So on the one hand, I believe it's contemplated that any licensee of the state bar I'm sorry, any paraprofessional would be licensed by the state bar. I'm not sure exactly how far you've gone on that, but that the paraprofessional would be licensed by the state bar after satisfying the qualifications, education, experience qualifications, whatever requirements you might recommend and would be approved by the California Supreme Court. They would be licensees, so arguably they would fit within, they would be licensees of the state bar. The state bar were going to be the regulatory body that's going to regulate the practice by paraprofessionals. Would there be any change that would be needed? Arguably not, but you'd probably want to run it by the legislature to make sure that the legislature was on board with that. The other point I'd like to make with that respect is the concept that, excuse me, that specifically I was brought here to talk a little bit about appearances in court. And I was taken particularly by the mention of our friends from Canada referring to advocacy. And we have an adversary system here in the United States, and it really only works. And I think that's why most of us are, or I should say, that's why we're here today and why we're trying to provide assistance to people, because the adversary system works best, is most effective when the parties within the adversary system are represented by people who are skilled and knowledgeable in the law, at least to some extent. And there's been talk, well, you don't have to be a brain surgeon, you don't have to be a lawyer necessarily for every legal issue that might arise within our court system. But still, it's important that we have someone involved in this advocacy. Well, an advocate isn't going to be able to perform his or her functions unless they have the facts. And underlying the attorney-client privilege, it's referred to as the lawyer-client privilege, is the concept that you can tell a prospective client, you can tell me pretty much anything. And let's face it, we don't like, I mean, we tell stories about ourselves. We usually put ourselves in the best light. Clients do the same thing. They have a tendency to put themselves in the best light. They tend not to be fully candid. And the concept is if they are told that, listen, what you tell me, I can't disclose, and I can't even be forced to disclose what you tell me, except for the one exception, death or substantial bodily harm here in California. So tell me what happened. I don't care if it's embarrassing. I'm not going to judge you. So if you're going to have a paraprofessional in court effectively representing someone, and if you expect them that they're going to be able to acquire the necessary facts of the client's matter in order to provide them with the tailored advice and tailored strategy on how to proceed, that's going to be important that there be a privilege. Here in California, privileges can only be created or modified by the legislature. The court can't do that. So that would be an issue that I think would have to be addressed in the statute and getting the legislature involved for any paraprofessional who appears in court. Similarly, here in California, unlike many jurisdictions where it is common law, attorney work product is also legislative. It's also by statute. So you need to consider that that is going to be an area where it is going to have to be addressed. The other thing that you'll see in the Business and Professions Code, let me just mention the attorney-client privilege is in, lawyer-client privilege is in the Evidence Code. The work product is in the Code of Civil Procedure. So there would have to, I think there would have to be some mechanism that would need to be done. Perhaps you've discussed this, and perhaps the leaning is maybe it won't be necessary to be done by statute, but at least as to the privilege, it would be critical. The other issues as to being in court, there are certain provisions of the Business and Professions Code, specifically section 6068 B through D, and F and G, which deal with requirements for lawyers who are appearing in court. And it only refers to the introductory paragraph of section 6068, says it is the duty of an attorney to do all of the following, not it is a duty of a licensee to do all of the following. So that is something that you might consider needs to be addressed. Some other issues, and this is just thinking and talking with some other folks, local court rules, which talk about when a lawyer is filing a pleading, the lawyer must generally include their state bar number. I don't think that's going to be a particular concern. If you're going to license a paraprofessional, I'm assuming that they are going to be given, maybe I shouldn't assume anything, but they'll probably be giving a number. That would be an identifying number. And the local courts could address those situations. So there are issues that I think can only be addressed by statute. As far as the rules of professional conduct, the court rules, I know that some of you and the state bar, I know Mr. Fortescue and people in the state bar who are working, and other members of this group are working on trying to come up with revisions to the rules of professional conduct, the California Lawyer Rules of Professional Conduct, to tailor those rules to paraprofessionals. And Chapter 3 of the Rules of Professional Conduct address litigation issues, issues that are involved in litigation and going to court or perhaps appearing in court. And I think that's, I don't want to go on and on. I'm not as interesting as the stories of what's actually happening in the rest of the country. I love the stuff that I'm doing, but I mean, I realize it's pretty dry for most of you. So
no, we appreciate your being here and your, you know, we really did invite you because there were questions that have come up. And so I think that it would be helpful to take questions from folks so we can get answers to their questions.
Right.
Yeah, I haven't been paying attention to whose hand went up when, so why don't you take it away?
Yeah, I think it's Carolyn, Steve, and then Sharon.
Carolyn, we can't hear you.
Okay, what I had to say was genius, so it's all lost to time. No, good morning, Professor Morris. Good to see you again. I remember you from the ATELS one quite explicitly, and you did a lot of work on that committee. I want to thank you for that. But I think that one of the things, and I have a million questions for you, so I don't think I'll be able to get to everything, but let me just try and keep a couple. One of the things that you started out talking about was the change from 2019 from members to licensees. And I remember many times trying to explain and talk to people about this when the split was happening, friends and that kind of thing. And so, and you mentioned also there's the word attorneys that are used in the statutes in all kinds of places. Is it your sort of thinking that when those statutes were revised from being a member of a unified, or actually it's confusing. We have a unified state bar that was split into a regulatory agency, that's the State Bar of California, and then an educational entity called the California Lawyers Association. So when that split was happening and this change was made, is it your thought process that when you say we're now not members of the state bar, just licensees, that's sort of what we're talking about with regard to regulating paraprofessionals is a bit of a fait accompli. It's done. It's been already taken care of in 2019.
Okay, to answer that question would require me to go above my pay grade because it's a difficult question to answer because what's going through the minds, a lot of the revisions, just substituting licensees for members of the state bar are arguably just technical amendments that were made. By the way, we're just changing this uniformly. We're making a global search and change in the statute. The important thing to look at is the fact that we have broken off this other body that's called the California Lawyers Association. And we have this empowering legislation that's part of the Business and Professions Code that identifies the California Lawyers Associations that is separate and apart from the state bar, something that hadn't been done since the state bar's creation back in 1927. So the reason I'm hesitating to say that is that, yeah, you can make the argument, but is that an argument you really want to make instead of just going to the legislature and saying, yes, we now have paraprofessionals, they're going to also be licensees of the state bar. Is this okay? Now, in favor of the argument that you can just say they're licensees is there are the temporary lawyer license, that program that the state bar has enacted. I don't think there's an argument that those folks are going to be engaging in the unauthorized practice of law, but they're also going to be under the supervision of a lawyer. Okay, so you also look at, might it be cleaner because you also have a chapter in the Business and Professions Code under legal or chapter. There's chapter 4 for lawyers. Chapter 5, I think, is for the legal document assistance and unlawful detainer assistance. Chapter 5.5 is for paralegals. Now, would it be confusing, or do you want to eliminate any kind of confusion by also having a separate chapter for paraprofessionals, where you actually unambiguously clarify that these are licensed professionals of the state bar and that they are being authorized within the statute? So yes, argument can be made both ways, but once again, that's a policy decision, I think, for how the state bar is going to proceed. It's not something that you want, someone like me, who is just like I'm not a policy nerd, I'm a rules nerd. I like to get down and I like to draft rules. So I can't make those decisions. And that's going to be a decision that's going to have to be made at a recommendation can be made by this body, but how the state bar is going to proceed in making a recommendation to the Supreme Court and the legislature. It's kind of beyond my purview.
Okay, I'll pass the baton and maybe I'll come back later.
Okay, thank you.
Professor Moore, I'm Steve Fleischman. Thank you for coming. This is a question directed to you and Greg, if he's on the call. I understand what you're saying about 6125, and I understand what you're saying about 6002. Where I don't see this program can be enacted without legislative change is 6060. 6060 says, here are the requirements to apply for a license to the state bar. And one of them is passing the California bar exam. And the whole purpose of this program is to allow people who, for whatever reason, have not passed the bar exam to be able to practice law under the auspices of the state bar as a licensee. So, tell me I'm right, tell me I'm wrong, but I just don't see how this can be done without some legislative action.
Okay, and what I said, if you focus on there's 6125 licensee of the state bar, but then as far as the sanctions that can be imposed for a violation of 6125. You look at 6126, 6126.3. It also refers to licensees or persons who are otherwise authorized to practice law in this state. So the paraprofessionals might fit into that latter category, or otherwise authorized to practice.
If I could just jump in for a second. It's not a direct response to Mr. Hamilton, but I just want to keep reminding people that we are contemplating that there will be legislation. And part of that would be, of course, determining if there are any changes that need to be made, modifications, amendments, new statutes, deletion of rules. That process, my understanding is going to happen. So I do not think anyone is contemplating that we would be suggesting that a paraprofessional program be put in place while saying, and nothing needs to happen in regards to legislation. We can just fit it in under the current rules. I just want to be quite clear about that, because I'm a little concerned that based on Stephen's question, that there's some thought that we'd be trying to move forward, not understanding that there may need to be changes made. So I don't, I appreciate the conversation, but today we're really trying to focus on the in-court representation aspect of things. Greg, did you want to add anything?
There,
Right? Oh, there you are.
I have to come over three screens to get to my unmute button. I agree with you, Justice Petru. Nobody is suggesting that we would stand up this program without involving the legislature. I think in prior meetings, I have mentioned that the admission of individuals to practice law in this state is inherently a judicial function, and that the legislature has always been our partner in regulating the profession. The most important point, though, is that the court needs to authorize people to practice law. So to the extent that the legislature seeks to allow people, and we've had cases like this, the Hunstead case versus workers' comp, in which the legislature has materially impaired the court's ability to regulate the admission or discipline of attorneys, or allowing individuals who are not attorneys to practice law when not authorized by the court. Those laws have been struck down. And so I think both the legislature and the court they know that we are partners, and that we would, as Professor Moore said, there is an argument, which I have made in this body, in this working group, that I don't read 6125 by itself as barring paraprofessionals from practicing law, so long as the court says that they are authorized to practice law. But that doesn't mean that's the optimal resolution of this. And I'm sure that we would want to, as Professor Moore indicated, talk to the legislature to the extent the court is behind this proposal, and create a new chapter in the Business and Profession Code for this profession, so that it is clean and it is much easier for everyone to comply with the law.
Greg, Justice Petro, with that clarification, you two have taken a load of worry off my mind, and I thank you, and I pass the witness.
Thank you, but now you make me feel like I should be able to say, oh, and our work is done, but sadly it's not. Let's go on.
All right, Sharon and then Carolyn.
Okay, if I could just add one thing. Does anyone disagree with me when I focus on the attorney-client privilege and work product protections, or something that you have to think about if you're going to have effective representation by paraprofessionals in court? I
can't imagine, I mean, anyone can pipe up if they wish, but I can't imagine who would disagree with you on that.
Okay, thank you.
Oh, and I would just add, it occurred to me, and this is my other question, mediation confidentiality. We also haven't discussed that. I have raised a couple times the point of using any of this in evidence, especially administrative hearing communications.
So again, Carolyn, it's the same answer, right? In the sense that we will need to take a close look at things moving forward, and just like making sure that conversations are privileged as they are with attorney clients and work product, we'll have to make sure or the appropriate people, because I don't think it's going to be me, the appropriate people will need to ensure that that encompasses also the mediation privilege, that somehow by virtue of it being a paraprofessional rather than attorney, that those protections are not lost, because you raise an important point and it's something that we all need to keep in our minds.
Yeah, and if I might just add, please, the duty of confidentiality, which is not coextensive with the privilege, is much broader. So add that to the list of things that the needs to consider. Thank you.
Justice Petro, on the attorney-client privilege, I don't think it's as simple as saying, yes, the attorney-client privilege applies, because it will be a limited license. And so a paraprofessional.
No, I'm not saying it's as simple as saying the attorney-client privilege applies. What I am saying is that it's as simple as saying that we absolutely want that to be the case with the paraprofessionals, and therefore when the appropriate people and bodies are looking at what changes need to be made, that if there are changes that need to be made to maintain privilege, that needs to happen.
That's fine. We're on the same page.
Yep.
Okay.
So my question for the professor, because Carolyn asked my first question. So my second question is, when you were part of ADLS, did ADLS contemplate that paraprofessionals would be licensed to do full-on in-court representation for clients?
I don't recall it was discussed, but I think it was going to be left, because at the end, when we were discussing the paraprofessionals, the Board of Trustees had already decided that they were going to appoint this group. And we didn't delve too far into it at that point. You know, we're talking about that. We thought that paraprofessionals is a great idea, but I can't recall that we got very deeply into any discussion about in-court representation.
Okay, the reason I ask is because I heard from another ADLS member that it was not contemplated, but it sounds like it was not fully discussed.
That's correct.
Thank you.
Julia.
Good morning, Professor Moore. This is Julia Brynelson, and I am interested in knowing, based on your experience, do you have an opinion or input that you could provide us based on the discussion today regarding in-court representation by paraprofessionals? Is that almost as if you were, I guess, an expert witness on the issue of ethics and what we're discussing here and what we're mulling around? Could you help us, or do you want to play hands off and not contribute at this point?
It's difficult. On the one hand, I'm a lawyer and I love to talk and give my opinion. On the other hand, I don't really want to jump into the fray and make any comment other than I think probably there are some things that you do in court. You know, as part of my research, when I was asked to look into this, I looked at physician's assistants. And here in California, I know it's that they're under the supervision of a doctor, and they are permitted to perform minor surgery. And so I said, well, what's minor surgery as opposed to major surgery? And I started to do a little research. And what I found is that major surgery is defined as entering a body cavity, cutting in and entering a body cavity, or cutting through muscle. And anything other than that is going to be a minor surgery, which physician's assistants might be authorized to perform. So the task might be to identify, perhaps other than what's done in Canada, where it seems they delve a little bit into major surgery by taking a case all the way forward, is to trying to figure out what might be the analogy or analogous minor surgery that you would be willing to let paraprofessionals perform in a court. And I'm not sure whether that would be workable or and how you would go about doing it. I couldn't come up with a good reason, but I think it's a great question to explore.
Thank you very much.
Thank you.
All right. And that concludes our external presenters. We did ask Judge Wiley and Nicole to speak as well. Thank you, Professor Moore.
You're welcome.
Judge Wiley, are you
I think
ready?
Ira, did you just raise your hand?
Oh, sorry, I didn't see that.
No? Okay.
So I'll go first. Before I begin my remarks, I want to thank the committee members for allowing me an opportunity to share my thoughts on this very important issue. I'm on a lot of committees, a lot of task force, and believe it or not, this is by far my favorite. Yes, the meetings are long, and I have had longer lunch breaks when I was in kindergarten, but the deliberative process that has gone into all of the meetings that we've had and the conversations, I think is fairly unique. So I want to thank all of the work group members. The question of really whether we should allow paraprofessionals to provide in-court representation or in-court advocacy is not really an abstract question for me, because I've been now in family law for 8 of the 11 years that I've been a judge. And in family law, you have such a high number of people who are representing themselves, and they come to court. Some are articulate, some are not articulate. Many of them are not articulate. What they come to court to fight over is not money, it's not their liberty, it's their children, it's their families. And a lot of the time, those are very emotional cases. And we as judges in family law are looking really for information that we can use to make the best decisions in an incredible situation. And we're faced with that, not just once or twice a day, but that is literally every single case that we have. From 2011 to 2013, and again from 2014 to 2016, I was in a very, very high volume family law court. So I would see these cases, see people come into court, trying my best not to intimidate them, but knowing just by virtue of them walking in the door and arguing about things that are so precious and important to them, that the situation and circumstances could not help but intimidate them. And I think that when we train judges, and I do a fair amount of training for our new judges orientation and our judicial college, what we really ask our judges to do when they become triers of fact is to look and find sources of information, resources and tools that they can use in order to make incredibly difficult decisions. So this information gathering, as I like to call it, happens every time we're in court, both the pleadings that are presented to us that we read in advance and what happens during the court proceedings. We allow in California lay expert opinion testimony come in. So if you're someone who has a specialized skill, knowledge, training, or experience, you can come in. We'll designate you as an expert pursuant to Evidence Code Section 720A, and you'll get to give us your opinion about something. Well, I think we all remember the movie My Cousin Vinny, which for obvious reasons, won Marissa Tomei an Oscar, and how she was used as an expert in that case. Ever since we started this conversation, that movie has certainly been on my mind, because I kind of look at the paraprofessionals and what their role in courts and in these cases would be as really the experts for these cases, and the importance of the advocacy in court that they would provide to their clients. When they prepare the papers for the clients, when they meet with the clients and investigate the facts and circumstances of what the situation is, and allowing them then to come into court and provide advocacy, I think is so critically important to the work that we're doing and the program. I cannot see the program without that piece and that component for a lot of the reasons that I've said. I want to tell a story, and unfortunately, I can't claim credit for this story because it was a pre-pandemic domestic violence conference that I went to in New Orleans where this story was told. But it was so powerful when I first heard it. And as we, again, have had these conversations, I keep thinking of the story. And I call it the cup story. And it happened in a courtroom where there was a domestic violence case. A woman came in with her sister. The sister sat in the back and the woman came forward when the judge called the case. The woman was so overcome because she'd had a very, very abusive ex-husband that the only thing that she was able to articulate to the court at that time was 2 words, and really 1 word perhaps, coffee cup. But she kept saying coffee cup. And the judge is getting a little bit frustrated because he's not able to ask her questions in order to make the ruling on whether a restraining order should issue against her ex-husband. The sister's in the back of the room, and this judge, like many times I have done in my courtroom, I see the sister raise her hand, and it always amazes me when people become very, very nervous in the back of our courtrooms. They'll raise their hand like they're in elementary school. Perhaps, you know, that sense of higher authority at some point past time in their lives, but they'll raise their hand. And this judge asked the woman's sister to come forward. He swore her in, and he asked her, what do you know about this situation? And the woman's sister was able to articulate for the woman that the coffee cup that she was referring to and that she was so overcome and really unable to tell the judge why she needed a restraining order today had been found in her locked car parked in front of her home. It was a Starbucks cup that was still warm from the Starbucks 2 blocks from her home. And it had the woman's pet name that her ex-abusive husband used to call her. So when she saw the coffee cup, it was, he's here, he's back. But she wasn't able to tell the judge that. Her sister knew the story, her sister was able to articulate that. But what if you have a situation where you don't have someone who's there in court? And, you know, when I heard Christina and Dana tell us their experiences, I heard the words empowered. I heard the words, my voice was heard. And that's really what we're talking about. Because as we're making these decisions about whether paraprofessionals, and there will be some good ones, there will be some excellent ones, and there will be some bad ones, just as there are good, excellent, and bad attorneys. We really need to think about who this is affecting, whether this is really an equity issue and an access to justice issue. And I trust in the licensing, regulation, and education that we will provide our paraprofessionals to be able to come into court and provide advocacy, representation, and answer questions that courts and judges may have about these situations. So I'm certainly not as eloquent as Judge Yu in her letter that we all reviewed prior to today, but I can only echo everything that she said. Because from a perspective of a sitting judge, this is to have a paraprofessional program without allowing the paraprofessional to answer questions, provide us information, I think it would be a farce. So I want to thank everyone for the few minutes that I have. And again, please, as we make this important decision, remember the people that this is actually affecting and the lives that we are trying to improve with this program. Thank you.
Thank you, Judge Wiley. I just wanted to pop your comment about our abbreviated lunch breaks prompt me to comment that we're not taking a lunch break today since we're ending at 1. However, I think we do need a little, sanity break pretty soon. So my thought would be that we hear from Nicole and then we, take a 10-minute, just everyone can stretch their legs or do whatever they need to do before we resume.
Thank you for letting me shame you into that concession.
Yes, you did. Yeah, so everyone can thank Judge Wiley for the upcoming break. Nicole.
Thank you. First, I'd like to say thank you to the committee and to all of the speakers, but especially to the clients. I shared their sentiment in the need for in-court representation for a paraprofessional. Oftentimes, as a consumer, our voices get lost when we need representation. And so I've heard some key words. It's cost, access, and advocacy. And for me, cost as a consumer, whether I would select an attorney or a paraprofessional, cost is something that's key to me. I am a cancer patient, if anyone hadn't known. And so some of my expenses are a little astronomical. So I am really zoned in on cost, access, and advocacy. So often as a consumer, it's all about trust as well. And just listening to some of the clients, I could hear from them, they felt this level of trust that they were able to experience. Sometimes I think that might get lost as well. So we need that level of trust, that empathy. It seems like I heard that as well from the other clients. There's that lack of empathy sometimes. And sometimes I think as a consumer, we feel like we just become a case number, right? And so our voices get lost. And then we also, if there is negotiations that happen, sometimes we feel like there's just an agreement between attorneys, and then what happens to our voice, we get lost in that process. So I really am also want to echo the sentiments of the letter too that was shared by Jason Solomon. He also mentioned advocacy. So it's really, really important to me, and I believe it would be great to have access to a paraprofessional to represent me in court. So I echo the sentiments of everyone. Judge Wiley too, that was a great story. But I say yes to that. I echo everything that has been said based off of clients. And thank you even too from Ontario, the representative, the speakers from Ontario. I am all aboard for having that in-court representation.
Thanks, Nicole.
Thank you. So it's 11:15. Let's take a 10-minute break. I am planning on, you know me and timing, I am planning on starting at 11:25 sharp. So we are going to get going, I think at that point with public comment. And so then we can go into our full group discussion. All right, see you all in a few. If I could ask, please, that any attendees who wish to make public comment, if you could please raise your little virtual hands.
Looks like.
And Linda, are you back with us?
Yes, she is.
Okay. So I see 4 people currently, 3 minutes each, please. And Dana, were you saying something?
Just making myself known.
Oh, duly noted. Okay, so Linda, I think we can get started.
Yes. Helen Bellamy.
Hello, good morning. It still is morning. I've been on the Zoom call since 9 this morning, and I did have the opportunity to listen to what's going on. There's a little nervousness in my voice again because I am so passionate about this issue. The legal document assistant, even though that is what I am, that's the profession that I work in right now. But it really is all about the legal consumer and access to the law. I've been providing services for 29 years. So that means that this is not new. People are looking for help with very basic and emotional issues that affect their lives. And to not be able to find it as easily as an attorney, that is such a problem. And this is an interesting situation that's going on now because I had no idea that other places were so far advanced in California. And I thought California, we were the forerunners of everything. We were the trendsetters, but I actually see that we're not. And that's disheartening because, as I've said so many times to the committee, helping the legal consumer access the law and to understand the law and to be empowered to help themselves, that's what I thought that's what we were supposed to be doing. But when I see and I understand that just when my customers call me and they say that they can't find help, you know, I remember, and I will hurry up, I remember I had to come to that place where my customers are not dollars, they are real people. And they really do need to have help filling out documents, understanding what those documents are. Because when they understand that, that's when they can go up and speak for themselves. But we all know that sometimes, just like there's nervousness in my voice, people get nervous. And it's good to have a buddy system. And that's some of what this court representation is being talked about. So I am again urging you to think about the legal consumer. The law belongs to
30 seconds remaining.
Okay, there we go. It belongs to all of us. So give it back to us. Thank you.
Linda, do you want to call the next speaker?
Jeannie Harrison.
Hi, good morning. Can you hear me?
Yes.
Okay, great. Thank you. This is Jeannie Harrison. I practice law in Los Angeles, and I've spent 28 years litigating and trying employment-related civil rights cases. I'm the president of Consumer Attorneys Association of Los Angeles and am consistently named by the Daily Journal as one of the top employment lawyers in the state. In fact, now for 12 years. I'm also named by Super Lawyers as one of the top 5 super lawyers in Los Angeles for the past 5 years. These are just some of my bona fides, which I share with you only to say that I have substantial experience in the areas in which I'm talking about. I use FEHA and labor code claims to create systemic reform, just as those laws are intended and is as is legislatively enshrined as being the state's public policy. I've gone against institutions and people big and small, from representing many women against Harvey Weinstein to reforming the Los Angeles Fire Department, and now to representing the women of Riot Games in their equal pay class action and PAGA penalties case. Wage and hour cases include equal pay cases, like the Riot Games litigation I'm waging. We are litigating complex issues of comparability, intent, and malice, oppression, or fraud against law firms like Gibson Dunn. My firm and Gibson Dunn are 2 of the same firms on the $850 million USC settlement announced just yesterday. Employment and wage and hour cases are all high stakes and complex, where losing likely means personal bankruptcy for the plaintiff due to the costs assessed against them. I've attended most of the committee meetings, including the Employment and Income Maintenance Subcommittee meetings, as have many other top practitioners and legal aid organizations. Virtually all have spoken out against having paraprofessionals handle employment and wage and hour cases. Based on extensive, thoughtful commentary in these meetings, the subcommittee got it right on wage and hour cases, which is not to allow paraprofessional representation in affirmative relief superior court cases, just like they got it right about employment cases, and as the committee adopted. Tens of hours have gone into those careful assessments based on major stakeholder comments, and the process is working. That's why I urge the committee to adopt the Employment and Income Maintenance Subcommittee's recommendations in wage and hour
30
cases,
seconds remaining.
and that there be no default position other than allowing the subcommittees to do their work and make well-reasoned recommendations. Thank you very much.
Ken Goldman.
Can you hear me?
Yes, we can.
Okay, thank you. Thank you very much for your time. My name is Ken Goldman. I'm an attorney practicing wage and hour law in the Los Angeles area. And I oppose the paraprofessionals representing employees in or out of court on wage and hour matters. Others will or have discussed problems with federal questions that are raised in wage and hour cases and how that could affect removal and with respect to the representation. And I know that there are also concerns within the plaintiff's bar, as well as likely with the defense bar with respect to mandatory arbitration provisions for disputes that may affect representation, including the legal work to oppose those coercive and adhesive requirements. But I want to talk about how this proposal will affect the economy of justice. I understand the three most important or pressing reasons for considering the use of paraprofessionals in wage or in the legal system would be for access to justice, reduction of costs, and efficiency. But this proposal will increase those burdens with more cases at higher costs to employers and will have the effect of creating cases driven by legal fees. Here's how. My practice is primarily in the wage and hour class action arena. And in fact, in disclosure, I'm not 100% certain, but I do believe that I've been co-counsel with Ira Spiro in the past, and if not directly with Mr. Spiro, with his former partner for certain. In the practice of class actions, we often have individual claims that are too small for an attorney to take. And in fact, previous speaker invited by the panel, Ms. Corsetti, said that to spend a day in court for under $10,000 is not something that attorneys generally want to do. And in fact, that's correct. And that's why the economy of scale of a class action makes a lot of sense. And judges are, of course, charged with acting as fiduciaries for absentee class members and to ensure that their rights are affected. But the effect of allowing paraprofessionals here would be to allow
30 seconds remaining.
Would be to allow paraprofessionals to use the 30 to 40 or 30 to 60 day opt-out period to solicit individual cases that are driven by the recovery of legal fees. And you're going to end up with higher costs to employers. You're going to end up with small cases clogging the court system, driven by the recovery of attorneys' fees on cases that should have been handled in a group measure. Thank you for your consideration. I hope that you will refrain from allowing wage and hour work with paraprofessionals. Thank you.
Right, Sedek?
Good morning, everybody. This is Jenna Myra from Betzetic Legal Services in Los Angeles. I've been listening all morning and I've appreciated the thoughtfulness of this conversation. As a number of legal services organizations said in a letter we sent on February 25th, we strongly oppose in-court advocacy by paraprofessionals, particularly without attorney supervision. Importantly, several of the models that have been cited in support of in-court representation, law students who perform well in court, limited scope work, such as the type I understand Fariba's program in Santa Clara to provide, all have attorney supervision or are housed within nonprofits, such as the Department of Justice's accredited reps who work in immigration courts. As the Utah Supreme Court's Office of Legal Innovation found, the risk to consumers is much higher without attorney supervision, and it is dangerous to combine the high level of risk with the high stakes of in-court advocacy and representation. The risk is only heightened because it's relatively untested. Arizona hasn't started full in-court rep. Washington only allowed it with limitations for a short period of time. And Canada's program built on an existing paralegal scheme and moved extremely slowly. As we heard this morning, 15 years in, they are only now considering adding family law. If California is determined to go down the road of in-court representation, I would respectfully suggest that we are too big of a state and too complicated a court system to go first and to go as fast as this working group seems to be considering. We are also concerned that the middle options, limiting the type or scope of representation that a paraprofessional can provide in court, will sow confusion and frustration amongst litigants and bench officers as they try to navigate the technical rules about what is allowed and what is not. As Dave Byers noted, the most common complaints about LDAs in Arizona is that they have exceeded the limits of what they are permitted to do, which is perhaps a natural but still dangerous consequence of permitting a little bit of something. Finally, we have reason to question whether paraprofessionals would have a significant impact on the number of self-represented litigants. The 2019 Judicial Bench Guide about self-represented litigants said nearly 70% of the almost 500,000 people each year who use self-help earn less than $2,000 a month, and nearly 85% make less than $3,000 a month. Thus, the overwhelming majority of self-represented litigants are indigent. They qualify for a fee waiver, legal aid, and likely could not afford to pay a paraprofessional much, if anything. So permitting in-court representation would create a lot of
30
risk
seconds remaining.
without a lot of upside. And while I recognize it is beyond the purview of this group, I want to remind you that there are other ways to narrow the justice gap. Increased funding for legal services, support for sliding scale models, modest mean programs, expanded self-help resources. We are concerned that a paraprofessional scheme that allows in-court representation will further decrease the will to really put our backs into improving those types of services. We strongly recommend that paraprofessionals are not permitted to provide in-court advocacy of any kind. Thank you very much.
Andy Fields.
Good morning. My name is Andy Fields, and I'm an attorney in California. I am also a member of CELA's Wage and Hour Committee. I'm speaking today on behalf of Leonard Sansanowitz, who was unable to stay on this call towards the end to make comment. These are his words. Even at the limited jurisdiction level, MSJs and wage and hour actions necessarily would involve complex legal issues. Here are two examples of MSJs I had to oppose. One regarding joint employer. Frequently, there is a good cause to name more than one entity in a joint employer. In California, this can be established in three ways. First, the wage order definition. An entity is an employer if it controls the employee's hours, wages, or working conditions. 2, the entity suffers or permits the employee to work. Or 3, the entity engages in the employee to work, common law, basically the Borello standard. This is an extreme fact and document intensive inquiry, which requires multiple depositions, analysis, of usually hundreds of documents and many hours of putting work together in the separate statement. Outside sales exemption is another section. The employer must prove that the employee customarily and regularly spent more than 50% of their time on selling tangible items or on obtaining orders or contracts for products or services. This is an extreme fact-intensive inquiry that also can turn on the definition of sales. Second, most wage and hour statutes have one-way fee-shifting statute for prevailing plaintiffs under the Labor Code Section 218.5, and a prevailing defendant on issues of time paid wages, for example, could recover fees as well as cost. And third point, if the paraprofessional charges an hourly rate, the client is out thousands of dollars in a losing effort. If the paraprofessional is allowed to charge a contingency fee, the paraprofessional will be out dozens of hours of time that could have been spent representing claimants at the DLSC. Thank you so much for your time. Hello, can you hear me?
Yeah.
Okay, wonderful. My name is Angela Grijalva. I'm a legal document assistant here. I specialize.
Actually, I don't think we can actually hear you very well. And Linda, have you started the time for Angela?
Should I?
I don't know if you can speak closer to the.
How about you skip me? I'll log in on my cell phone and do it that way. If that.
Okay.
Thank you.
Linda, you're on mute.
Eric Kingsley.
Hi, good morning. My name is Eric Kingsley. I'm an attorney. I do mostly employment and wage and hour matters. I've actually had several published opinions, including last year, the decision of Kim versus Raines in the California Supreme Court. So I'm pretty familiar with wage and hour matters. I just had a couple points here. I think that our Canadian friends made some really interesting points about looking at the risk and the problems in a case. And I can't remember her last name, but Kathy, the woman that was in court handling matters and small claims and other unlawful detainer matters, that those are certainly laudable claims where there's not a lot of lawyers practicing in that area. But wage and hour, I think, is different in the sense that there's a lot of lawyers practicing in that area. I think that the subcommittee on these issues got it right to allow paraprofessionals to practice in the DLSC hearings as well as collection efforts. My concern is with just any type of practice that has multiple disciplines, in the sense that employment has discrimination, harassment, retaliation, wage and hour, among other things, as well as the fact that there's a lot of federal overlays. For example, overtime has a federal statute, the Fair Labor Standards Act, that can be brought to bear. And certainly if paraprofessionals aren't allowed to practice in federal court, that can have serious ramifications. There's union preemption issues and the like. So I think the committee got it right by leaving the paraprofessionals in the spaces where perhaps you don't see lawyers as often as the Canadian example demonstrated, and not allowing a default rule. I think especially with contingency practices, you tend to see lawyers in those spaces in the sense that it's not about the individual's ability to pay, it's about the potential value of the claim. And so while I think in the DLSC, there may be some smaller claims that are underserved, by and large, wage and hour claims are fairly well served in the courts. Thank you.
Chris Dolan.
Hello, good morning. My name is Chris Dolan. I'm the former president of the Consumer Attorneys of California, former president of the San Francisco Trial Lawyers Association. I practice employment law. I've won awards for the Trial Lawyer of the Year for the City of San Francisco and the State of California for employment cases. I have participated in the working group. I employ paralegals, lawyers, legal secretaries with a firm of over 50 people. And I'm here today in opposition to having paraprofessionals appear in court for the following reasons. First of all, a paraprofessional will not have the same motivation to direct people to publicly available services through the Labor Commission, the Industrial Workforce Division, and therefore they have an interest in charging an hourly rate where there are matters that could be handled for free. Second, in a trial court, you have to preserve a record for appeal, and that requires knowledge of the evidence code and things beyond mere assistance, because if you don't preserve your record for appeal, we not only will have people who are applicants losing their case, but no way to overturn that on appeal or have a record based upon appeal. Additionally, paraprofessionals aren't going to be able to issue spot the same way that lawyers do. And by issue spotting, I mean, if an individual comes in with a claim, they may have several issues. There might be a glaring one that the paralegal is aware of, such as a failure to pay wages, but there could also be a disability discrimination case. There could be another aspect of an employment case. I've been doing this for 28 years, and I issue spot the cases that come through my office because even the lawyers practicing 10 years or less often miss them. The paralegals who work in the employment department in my office, I would not trust to go to court to represent any of our clients. Indeed, I would think it would be malpractice for me to do so. So this is a very arcane area of the law, that requires special attention. And while paraprofessionals are indeed a valuable part of our legal system, they are not lawyers. They don't know how to preserve a record, issue spot, or direct people to publicly available resources, and have a financial interest not to do so. Thank you for allowing me to appear today.
Thanks, Linda. Can we go to Angela since it looks like she logged back on?
Yes, Angela.
All right, can you hear me better now? Can you hear me now?
Yes.
Okay, wonderful. So my name is Angela Grijalva,
Thank you.
and
I'm sorry, I was appearing in front of a court, believe it or not.
I'm sorry.
Can you unmute Chris? Can you mute Chris Dolan, Linda? Thanks. Okay, go ahead.
Thank you again. So my name is Angela Grijalva, and I'm a legal document assistant here in Sacramento County. I primarily focus in family law issues. So I would like to speak. We have a lot of not-for-profits and, I guess subject matter interests come in and they are the majority of the naysayers of why this task force should move forward with whatever project is underway. And in this instance, representation in a court. So the last speaker spoke to motivation and interest of the paraprofessional to refer individuals to affordable services. Well, in this capitalistic economy, I don't think under the current conditions, that doesn't happen right now anyway, which is why we're in the mess that we're in. So I don't know how viable that is. And then the other argument that he wouldn't trust a paralegal, one of his own paralegals to go and represent. Well, of course not. They wouldn't have the education and training that the paraprofessional would. What I hear is fear from innovation and making systemic and social change, because that's what this profession would do. I don't know about the wage tasks, whatever the cases. I specialize in family law, but I can tell you that giving individuals voice, right? Because we're talking about the individuals who can't afford counsel. They can't afford a $5,000 retainer. In Sacramento County, it's about $500 for an appearance is the average fee. A paraprofessional would make that appearance more affordable. I'm assuming we'd have to see how it plays out, but the long and short of it, I'm sorry, I'm going too long, but the long and short of it is, we need to innovate. We need to provide other options. We need to break up this monopoly, and the people need assistance voicing their issues. When they get in front of the courts, they don't know how to identify. I can't tell you how many declarations, I spent an hour listening to their issues, and then I help them filter that, organize it. So what are you saying? What do you want? What would you like the court to do for you today? Right? And this is not practicing law. This is asking questions, getting to the root of the issue. And so why is that information relevant? And how do we communicate it to the judge so that they can then help you? So that's what my job is. That's just editing, right? And then it would be nice if I could go up there.
30 seconds remaining.
It would be nice if I could go up there and communicate that and help both the bench and the client. So I would like to be a paraprofessional. Thank you.
Cindy Panuco.
Good afternoon, everyone. My name is Cindy Panuco. I'm the Vice President and Chief Program Officer of Public Counsel, one of the nation's largest nonprofit pro bono law firm. I'm also the former president of the Mexican American Bar Association of Los Angeles County. I also appreciate the thoughtfulness. I've been able to listen into most of the conversation and comments that were given today. And I just want to echo what my colleague in legal services, Jenna Niara, the comments she already offered to us. In the interest of time, not to repeat, I will just piggyback off of some of those and also address squarely some of the issues that have been raised kind of at the forefront today, particularly as the plight of self-represented litigants and persons who can't afford attorneys seems to be, being used and co-opted as a reason for allowing paraprofessionals, when we know that these same self-represented litigants that Judge Yu and Judge Wiley so aptly described the plight and the challenges that they face, they wouldn't be able to afford these paraprofessionals. And when I heard some of the consumers speaking today about how helpful it was to have someone at their side during these very difficult moments, I didn't hear that they, wanted a paraprofessional. What I heard is that they wanted representation. And what if today, instead of, imagining or trying to institute, or essentially, what if today, instead of trying to create a two-tier system of justice, which we heard from one of the experts today, the ethicist, Mr. Moore, that, the adversarial system is one where you have to have, it only works if you have representation on both sides. What we're looking at today is creating this two-tier system of justice where in court, those who have resources have quality representation, and those who do not, which Judge Yu and Judge Wiley and others have described, will have a lower quality of representation. What if instead of talking about that today, we were imagining a system that's not two tiers, but we're creating a right to counsel in the times that we're spending here today? What if instead of institutionalizing a two-tier system of justice, we were instead talking about how we could have a residency for trained attorneys to always serve these self-represented litigants whose stories are being used to make the case for needing paraprofessionals? What if instead of creating this two-tier system of justice, we were instead today talking about
30 seconds remaining.
Making sure that everyone who wants an attorney got one. And today I didn't hear from any of the low-income consumers who are going to be most impacted. What we heard was from some of the consumers who weren't even told about the various options that they could have in legal aid. So respectfully, I'd also like this body to consider that in-court representation by paraprofessionals is not the answer, and to remind us of the various other options that we could be pursuing that would instead create an equitable justice system where both sides in court are represented by the same level of quality representation. Thank you.
We don't have any other public speakers who requested to speak.
So
All right, then Judge Rubin and Leah, I'll leave it to you to move us forward.
Yeah, Linda, can you put up the power? Okay, sorry, I'm changing rooms right now. So at the request of some members of the working group, we put together a few slides, which Linda has sent out. So I'm really not going to spend much time going through these at all, but just to remind everyone of the decisions that have been made. So here on the screen, you see consumer debt, what's been excluded, what is planned to come forward to you for consideration in April. If you can move forward. Collateral criminal, this is the area where we are the furthest along, the practice areas that have been included and voted on. You can go forward. Employment and income maintenance, we heard a lot about that today. We have had a lot of interest in the employment and income maintenance subcommittee, and I think perhaps some of our public commenters thought this was going to be voted on today. But the two remaining outstanding issues in employment are going to be addressed at the April meeting. You can move forward. Family, children, and custody, you all have seen this recommendation, at least a first pass of it in February, but you will be asked to vote on family law in April. Also coming forward in April will be a recommendation on conservatorships and guardianships. Health coming forward in April as well. These are the remaining issues under consideration for health. Housing. And go forward, Linda. So with that, we just transition right into the in-court representation discussion. So there are several different options under consideration. If we can go forward, I think. All right, so the first option, Linda, was the last slide the first option? Okay, the first option is full in-court representation. Yes, Carolyn?
Go ahead. There's a point where I want to jump in, but you're going, after you list all the options, I'll have something to add.
Okay, and I'm going quickly because I really want to just get into the discussion. And we did review, we sent the PowerPoint out, and then with respect to the options under consideration, this is really just a summary of what we heard from our working group presenters on these issues last time. So full in-court representation, these would be some of the arguments for full in-court representation. And then here you see in-court responsive representation. So that is where the paraprofessional could respond to questions from the bench, but not affirmatively advocate. Our third choice, in-court support, but a prohibition on addressing the court. So sitting with the client, but not being able to address the court. And then the fourth would be in-court appearance prohibited. And so with that, I don't think we have any other slides, right, Linda?
We just have the draft resolutions to be considered, but I think that's premature at this point.
Yeah. So those are our options. Judge Rubin, I'm going to kick it over to you. We'll take the slides down. I don't know if you want to hear from Carolyn, Judge Rubin, or you want to make some remarks first.
If I'm on.
Carolyn?
Okay.
Hello.
Judge Rubin, did you want to go first?
I might.
Oh yeah, sorry, I misunderstood you. Go ahead.
That's all right. Just to kind of frame up a little bit, because we only have like an hour left, and we would hopefully kind of get through this. I thought I could just kind of take a moment to offer a couple observations, and I might be speaking only to myself on this, but to kind of help, I think, calibrate some expectations. The first is I wanted to thank all the client presenters and Ms. Robinson and Judge Wiley for really key and important comments. Certainly as a judge, it's important for me to hear these perspectives, and to kind of, Judge Wiley was especially, judge to judge, sort of help me again, sort of recalibrate and kind of remind me of kind of what's happening virtually from me. And these are important observations that are being made. A couple things. First of all, in some of the comments that I was hearing, I wanted to at least express my feeling that I come from this from a slightly different perspective. I'm seeing that the paraprofessional licensing is not going to crowd out anything. Certainly if the statewide filings are any indication, there's plenty of work. What we're going to be doing is adding another modality that services can be provided, especially in a very critical place, the working poor and other people who occupy the kind of the justice gap in terms of their access to justice and their access to the courts. The second thing is that I wanted to say was, I understand that I am sort of late to the process. I didn't join this committee until January, but from what I can gather and what I've read and part of my orientation and coming on board, is that really what I see us doing as we kind of embark on this part of the conversation is this working group is really tasked with coming up with an ideal, like our best assessment of what an ideal model would look like for paraprofessionals practicing in California, and what kind of the best policy is. I think other processes within the state bar are going to take into account other issues. For instance, at least as I understand this, and Ms. Katz and Ms. Wilson, feel free, as all the other lawyers in my courtroom, feel free to cut me off and correct me. But this is going to get turned over to the trustees, and they're going to have their own process. And in that process, there'll be more public comment, and lobbyists will start consulting on this and kind of what's realistic. And I don't know, and they're going to refine whatever we come up with to be something that they think that, because I agree with some of the commentators who talk about legislative involvement, they'll be talking more about kind of what is realistic, whether the whole package is, whether parts of the package, whatever it is. And so I'm not sure that this is that our role would be to, I'm certain we can discuss it from time to time, but I don't know that our role is to let political considerations in terms of what we think Sacramento would or would not do kind of govern what the outcome of our discussions and our recommendation would be. I serve on the Judicial Council. In terms of our structure, this would be closest to an advisory committee. And we expect, at least in that context, advisory committees to give it to us unvarnished and complete, and the council can handle kind of what other modifications need to be done through the public comment process and through kind of more another open discussion about it. Anyway, I don't know if I'm talking to myself to trying to kind of curb my expectations or if it's actually helpful for others to hear as well. But I thought I would share that. And with that, let me pitch it back to Ms. Wilson to call on our next speaker.
We don't have any more speakers. It's the open discussion that we are facilitating, but we do have Carolyn and Stephen with their hands up. Yeah.
Carolyn, I'm sorry, not Carolyn, Ms. Shining, you had your hand up and I'm sorry.
Oh, that Carolyn is fine. Carolyn is fine. I have a hard time calling judges David. It just doesn't want to come out. Okay, so the reason I wanted to go first is I'm kind of the gunner from law school anyway. The reason I want to go first was I've been thinking about this a lot, and I've been talking to Leah, and it's really great. I was given I volunteered to do the 5 minutes of no in court person. I was going to argue for no in court. That was my position that I took. Of course, I hope my dog isn't biting any of you. And I honestly felt a little awkward because we've done so much discussion and so much consideration, and there are so many needs in so many subcommittees. I think I'm on 3 or 4. And we've gone through all this debate, in court for this, out of court for that. You heard all the employment lawyers discussing the complexities of the different representation at different levels: administrative, limited court, full court, class action, federal. So what I wanted to suggest here, that never crossed my mind until literally last night, was that we're considering 4 options. There should be a no default option. What I understood from Leah learning and talking to her on Wednesday is that this is some kind of global position that the committee, the group is taking that we've never even considered before. From April through October, we did not discuss the issue of these 4 things as if this was a checkbox and that this was going to be it for forever. And all that subcommittee work where we've talked about this and that and up here and down here, this level, is going to be basically washed away, resolution after resolution where we discuss it with these 4 options. I didn't write them. I don't know who wrote them. And I don't want to be limited. I don't want to be seen as no court never. I believe in right to jury trial. I believe in lawyer representation. I believe in my ethical obligations. I take them very seriously. And I think a lot of the commentators do too. But I'm on this committee to think about these options. And if we just globally say, in court, no problem, full scope, we're going to be going against Arizona, Utah, Ontario, England, Minnesota, which is only under attorney supervision, maybe, Washington. No other state has taken a default position that it's fine for paraprofessionals to come into court. And I think that decision needs to be made where we've been doing it. Now, my understanding is that we're going to have to now go back in every subcommittee, and some aren't done and some are done, and carve out where in those subcommittees we didn't mean it. And I think we've already done that and spent hours and hours and hours of work. So what I'm thinking and what I would propose is that there's a 5th option, which is no default position. We've made all of these discussions in subcommittee. Good, bad, agreed, not agreed, unanimous, dissenting. I would hate to have to see this committee go way beyond what we've been working to do. So at some point, I really think we ought to think about, why are we picking amongst these 4 when we have gotten pages and pages and pages and pages of reports that already go into this, and we're going to wash all that away. None of us knowing sometimes what the other groups are doing. I don't know intimately what the family law people are doing. How can I vote on that? So anyway, that's my thoughts. I'm sorry to go on, and I want to be the person who thinks through these things carefully. And I don't really want to make a global vote on anything if until we're really done in the process, we know all the silos are combined and we know where it's going, rather than having to go back again and carve out these exceptions and make it so complicated that no one will ever know what we all meant to do.
Okay, so as I understand your comment, Carolyn, you're suggesting that there is no full working group discussion of in-court representation globally, but instead the decision on in-court representation is left to each each practice area to make a recommendation. And
I think discussing it is great. I don't know why we need a resolution right now in the middle of our considerations that nails us to some undefined. There's 4 options. I had 5 minutes to talk about no in court. So we've got these 3 other options that don't lay over anything else. They don't fit on family. They don't fit on, how do you fit that on wage and hour? How do you fit that one into, into criminal? How do you do it? Where are they meant to go? So now we got to go back and figure out, okay, are we 1, 2, or 3? And is it 1, 2, or 3 for conservatorships? And it's 2 for family law? That's not how we were supposed to be doing any of this. So I think there should be a no default. I don't know. I love discussion. I love debate. That's why I'm here.
Okay. All right. Stephen and then Steve.
Thank you. Give me a second to get to my notes. So, I had to advocate for the position of allowing the paraprofessionals to be at a council table, but not to respond to or participate in the proceedings. And my position in that regard hasn't changed, but I kind of want to put my comments that follow to share with the court the lenses and the assumptions that I've been working under, which I think are necessary so that you can give the appropriate weight to my comments. I joined this working group with the understanding a paraprofessional program is going to be created in California. I also came with the understanding that that paraprofessional program absolutely has to be providing services in the area of family law. As I've mentioned before, there's a reason why the California Lawyers Association recommended me to this group. It is because I have been a family law litigator for 26 years. When I was working with the family law subgroup and coming up with a very expansive program as to the areas in which the California paraprofessional is going to be able to promote access to justice and assist clients who currently cannot retain counsel, I did so with the understanding and belief that the advocacy issue would remain the province of the attorneys. And it was in light of that, as well as my dual role as a member of the licensing committee, that we deviated substantially from the educational and the experiential requirements required in other states. It was imperative to me, individually and as the representative from CLA, that we did not create an educational requirement or a practical requirement or other barriers that would limit the number of paraprofessionals that would be approved or licensed in the state of California. That's why we've got as our recommendation 1,000 hours of experiential, which we understand could be easily completed within 6 months, not the 3,000 experiential hours that were initially required in Washington. Our educational requirements are also significantly lower. And it was that lens of let's create the lowest threshold that's reasonable while maintaining consumer protections to make sure we get the maximum number of paraprofessionals who can assist family law litigants in all these areas. And I know the assistance is needed in family law. I know what the numbers are in terms of self-representation. I want the paraprofessionals to be there, both individually and as the representative from CLA, to assist in family law matters. But we need to be mindful of the types of issues that are addressed in family court. We're dealing with child custody, and in particular, custodial orders in cases where you've got one or both parents who may have substance abuse issues, they may have mental health issues, or there may be issues of domestic abuse. You're dealing with child support, you're dealing with spousal support, you're dealing with the equitable division of real property, business interests, and retirement accounts. And it's my experience and understanding from doing this for 26 years that all of those issues, they don't have an impact just in the moment. They have an impact on not just on the litigants and their children for a lifetime. And the decision that's made on our request for order calendar and that has been advocated by an attorney or not been advocated by an attorney could dramatically impact the trajectory of a child's life. So I have these competing balances, the weightiness of the issues that are addressed in family law, the complexity of family law issues where we draw upon practice areas, not just the evidence code and noting the code of civil procedure. We have to have an understanding of tax laws. We have to have an understanding of real property laws. We have to have an understanding of federal laws pertaining to not just Social Security benefits, but disability benefits, as well as the retirement accounts. We really have to be kind of like the Swiss knife of understanding of litigation areas, contracts, in order to be an effective advocate for our clients in family law matters. So it's through those lenses that I come from the perspective of that there should not be in-court advocacy by the paraprofessionals. A couple of points I want to make. While we've had speakers from other programs talk about why they think it would be a good idea to have advocacy, none of the speakers can bring us anecdotal or statistical information from their programs telling us what's happened in family court with that. Ontario, which has got the longest standing problem and the most successful, there was a reason I drew out the statistics that I found from 2019, showing that the rate of the licensees for paralegals in Ontario are half the rate of the licensees of attorneys. And the ratio is very substantial. They still don't have a family law program, and we can't get information from them to find out, is this going to frustrate justice if we don't allow in-court advocacy, or is it going to interfere with adequate representation of clients because they are making a not necessarily an access to justice decision, but a cost decision. It's going to be cheaper for me to have this paraprofessional. Again, the ramifications of what could be decided at a temporary hearing, even though it's labeled temporary, can be lifelong for children. So Arizona, they're saying they're going to allow the in-court advocacy. They don't have any of their LPs yet. They're still in the process of approving it. So it's my position, we don't have the statistical or anecdotal information. And I don't think that's provided by the public comment letter that we got dated March 25th from Jason Solomon from Stanford. And I brought these issues up at the last hearing, and I don't think his second letter addressed that. Again, references to Ontario are not helpful because Ontario hasn't dealt with family law. Number two, the statistical information that is referenced in Mr. Solomon's letter from Rebecca Standifer's article refer to a single community needs and access study. It was done in 2014. It was done in a single community in Illinois, and it only had 668 participants. Number three, what we're proposing, allowing the paraprofessional to be at counsel table to counsel and advise their clients, is allowing them to get advocacy services from the paraprofessional. You know, I want the court to be, this working group to be mindful of the fact that we have lowered the bar for the California paraprofessional in terms of educational and experiential hours from all of the other programs that in other states or jurisdictions that we have reviewed. We've done that to make sure we get the maximum participation and the most paraprofessional licenses to do the most effective work in narrowing the justice gap and the access to justice issue. So I'm concerned now that I've supported these lowered standards for both education and experience, and particularly in the area of family law, in order to make sure we got the most paraprofessionals we could. And now we're going to let them, with this lesser standard for education and experiential hours, become courtroom advocates. I keep in mind too, we've included family law in the pilot program, not because it's going to be tried temporarily, but because this is the first area we're going to do. And it needs to be there. But why can't we add the in-court advocacy later after we start the pilot program and we've got 6 months or a year of data from the participating courts where they can tell us this was not effective or it worked to have the in-court advocacy? It's easier to add the advocacy component afterwards than to take it away, in my opinion. You know, I don't think she used this term dismissively, but I'd remind the working group members, Judge Krieger, during her comments this morning, referred it to their Ontario paralegals as being lawyer-light, okay? Well, I didn't view that as being dismissive. I think it was recognizing it would be a lesser trained, lesser experienced professional able to assist litigants so that we can affect access to justice in California. But I think that lesser education, that lesser experience comes at the cost of not being able to be an in-court advocate for parties. I do want to conclude my comments. There was a letter that was submitted for professional comment, which I felt misstated the position I expressed during the February meeting. The quote was, one working group member, and it was obviously me, indicated in a prior meeting that including in-court representation risked the California Lawyers Association's CLA exercising its full political power to block the program. I contend that's an exaggeration and absolutely a mischaracterization of how I have worked with this committee and this working group to ensure we come up with a viable, successful paraprofessional program. You know, I feel I've been very supportive and promotive of the paraprofessional program. I know there have been comments made by other working group members who have acknowledged that. And my comments are based on, I have 26 plus years of being in family court. I know what can happen if things go sideways and the lifelong impact that it can have. And I think it would be a mistake for this working group and that we could cause irremediable consequences if we start off with the in-court advocacy and not get to that at a later point after we've got anecdotal and statistical information from the pilot program. I'm hoping that the court sorry, you're used to arguing this week, right? I'm hoping that the working group considers the fact. And by the way, I see Judge Rubin's picture right in my images. So I'm addressing you right now, Judge Rubin, when I say the court. I'd say, you know, I'm not trying to engage in hyperbole and I'm not trying to engage in fear mongering. What I'm trying to do is I'm asking this working group, based on what I've shared with the committee, the effort that I've put in, the stories that I've explained, the experiences that I've had, that work history, my other bona fides that I've shared with this group, and I don't want to repeat right now. It's those experiences tell me we should not include an in-court advocacy component in the beginning. And it would be inconsistent with how expansive of a position I have taken on behalf of CLA with regards to licensing and lowering the thresholds and the specific practice area of family. I make it expansive. And I have to now deal with the coffee cup because that was a compelling story.
I'm sorry, Stephen, we have so many other hands up.
Can I have 10 seconds, please, Leah?
1 o'clock. Okay.
Okay. So the coffee cup issue for me is there's nothing in our model that required that story to necessitate a paraprofessional to be in court advocating, because they would have heard the story and they would have put it in a declaration, and that judicial officer would have known what coffee cup meant before that hearing started. And
okay, we need to, Steve, so I'm going to jump. We really do need to hear from other people. So let's move on, please. And
right,
let me just say, we obviously all appreciate and aware of your hard work on the working group. Go ahead, Leah.
Okay, Judge Rubin, did you want to maybe set a time limit or something?
Hi, well, first of all, thank you, Mr. Hamilton. And I just think, why don't we try to, because I see my whole top row is lit up with hands. And I'm also, like Justice Petru, I'm very anxious about generally. So if we, and I think people like my courtroom because we do end on time, why don't we try to limit ourselves maybe to 3-4 minutes, and then if there's more time, we can come back and do multiple rounds if there's time. And at some point, somebody may want to make a motion, and then we can have it as part of our discussion. Just because there's a motion does not cut off discussion.
Right, Steve.
Yeah, I agree with Carolyn that the questions are wrong and are too limiting. I circulated that published opinion from one of Justice Petro's colleagues in the First District, which basically says, look, filling out a judicial council form with factual information is not the unauthorized practice of law. And that's where I've always seen our group going, which is allowing paraprofessionals to assist people in filling out judicial counsel forms to help them along in the process. So let's look at the substantive groups. Healthcare, no court representation. Name changes, gender changes, judicial counsel forms. If there's a court appearance, it's perfunctory. Same thing with collateral criminal. My understanding is family law and unlawful detainer practice is highly form driven, and that fits into the model. Am I okay with somebody making a court appearance on a name change? Sure. It's perfunctory, it's no big deal. But I have a real significant concerns about allowing non-lawyers to do jury trials or to do bench trials. And the way we have these 4 options set up, I don't have a way to voice that concern because, I mean, unless we're going to do it in each subcommittee, which is why I think Carolyn's idea is a good one, to let each subcommittee make their recommendations. And, you know, if you look at the other states, we learned today for the first time, Arizona may allow paraprofessionals to do jury trials in what we consider small claims cases. We have a different system in California for small claims under $10,000, no attorneys. So yeah, I can see how Arizona wanted to even the playing field. If one side has an attorney, the other side can have a paraprofessional. We don't have that system here. Washington has very limited in-court representation. Utah has none. And, you know, we are messing around with 400 years of common law practice and tradition. I agree with Steve Hamilton. We should tread very carefully. This is a pilot program. Let's get it up and running. Let's leave in-court representation issues until later. And I did want to say, Judge Wiley, wow.
Did you want to make a motion then, Steve? Because there could be another resolution, which is in-court representation, responsive in-court representation, but no jury trials or bench trials.
Sure, I make a motion to add that as an option.
Can you?
And Linda, I'm going to ask you to, I'm going to ask you to let people know when they've hit the 3 minutes, and when Linda tells you that, to wrap it up quickly, because I don't want it to be that we have people who've been waiting and waiting to be heard and not had an opportunity to say anything.
And Mr. Fleischman, if you could articulate maybe a little bit
sure,
more clearly what your motion is, so we can take that down and make sure we have it right.
My motion would be to limit in-court advocacy to prohibit bench or jury trials, summary judgment motions, and anti-SLAPP motions. So that those would be, you need to get an attorney for those.
Okay, Elizabeth?
My understanding is there are no demurs in limited jurisdiction. Sorry, Judge Petru.
Elizabeth? I think you're muted.
Ms. Olvera?
Yes, thank you. Thank you for all of the presentations. They were great. I loved hearing from the people who this is going to mostly affect. And so I wanted to share just something from the California Association of Legal Document Assistants. They circulated a survey to their membership to get an understanding of the role that existing LDAs would be able to participate in. And over 80% of the survey respondents, and again, the membership is made of retired attorneys, mediators, legal document assistants currently running self-employed businesses. Approximately 80% said that they want to be able to go into the court with their clients in some capacity. And so they would like to sit at counsel's table, and they would want to be allowed to answer the court's questions. And so I just wanted to share that with you guys. Also, we asked them if this program comes out, or when it does, who wants to be able to have more opportunities to help their clients in giving legal advice. And over 90% of them said they're ready for it, for the challenge, and they're excited about it. But the question here today before us is not should the self-represented litigant be only represented by an attorney. The question is, should the self-represented litigant continue to go to court alone, how 80% of people have been doing in the past for many years. It's an access to justice issue. So the question is not what should we do, it's what will happen if we don't create this avenue for people to be able to have the assistance that they need. You know, and we keep bringing up the subject of expertise, and you know, people are saying, well, only attorneys should be allowed to represent clients. I believe that paraprofessionals should be allowed to represent the clients because right now, two people can represent clients, the attorney and themselves. And so just having that extra level of expertise, the paraprofessional, just makes sense. Thank you.
Thank you, Elizabeth. Ira?
Briefly, about summary judgments, Steve Fleischman just mentioned that. I hope people, I sent in a memo to the whole group about summary judgments and plenty of appellate courts saying there are simple summary judgment motions. And also my memo said it's very unlikely there'll be a complex summary judgment motion in a low value case, in a limited jurisdiction case, because it takes so much money to pay somebody to do the motion. All right, then I just have a question. Isn't it true that the 4 or maybe there'll be 5 or 6 alternatives that we're considering now, they're just defaults?
Yes, so let me just jump in on that. Yes, the idea was in order to, because there seems to be from our prior conversations, a basic philosophical difference regarding in-court representation. And so yes, the idea was to have a default position that any particular subgroup could choose to opt out of, but then have to justify why is this different. And of course, Carolyn has suggested doing it, you know, subgroup by subgroup, which I have some concern is actually going to lead us back to where we are having a full group discussion about every subgroup item. But in any event, yes, Ira, the idea was to have a default position.
Yeah, okay. Well, I just want, it seemed that Carolyn was saying that no, you're going to bind this, that, or the other group to one of these alternatives, and that's not true.
Okay, let's hear, we have not had a chance to hear anything from Judge Yu today, so let's hear from Judge Yu, please.
Thank you so much. I wanted to just ask if Steve Fleischman would be willing to have a friendly amendment to his motion. I agree about jury trials and SLAP, but I'm not sure I agree about court trials, like simple court trials. So I'm asking if there could be a friendly amendment, and then I think I could support his resolution. I'm not seeing it, but I think if I heard it right.
Erica, if you're not concerned about the record-making process for a potential appeal in a family law bench trial, I will agree to that amendment, but I do so somewhat reluctantly, but I like to try to find consensus. I kind of would like to hear from the other judges on that also, but you know, if you guys aren't, if the judges aren't concerned about it, I give the judges a lot of deference on something.
So I think, you know, so I appreciate that, Stephen. I think that, you know, what we're dealing with is the reality, and I'll speak from my prior family law days, of the alternative is not having someone with an attorney. The alternative is having the self-represented person doing the bench trial. And that's what we you know, are dealing with. And that's what I see, you know, often. Like, that's what we're dealing with time and again. And so I think it was Elizabeth who kind of raised this issue as well, is to think about what alternatives are we talking about. So we're not talking about a bench trial with the self-represented individual versus a bench trial with a person who has an attorney. So,
but we have the Washington model where the paraprofessional would hand it off to an attorney, and we heard from someone today that works. So
they can hire one. I mean, that's the problem. Our experience has been that they cannot afford to retain counsel. And I certainly heard loud and clear, obviously there are going to be many people who can't hire paraprofessionals as well. But we do have some hope that there's a significant number of people who could.
With that comment, I agree with Erica's amendment. Judge Rubin, I'm sorry, I didn't mean to interrupt.
Oh,
Thank you. Oh, sorry, Judge Rubin. Thank you, Steve. And Justice Petru said what I was going to say about the record. Thank you, Steve. I appreciate always that you're so collegial and pragmatic.
And Linda, if you, when you get a chance to put up the document with the various resolution options, I think that would be helpful at this point. Judge Rubin.
thank you. I just wanted to answer Mr. Fleischman's question from my perspective, and it goes like this. I've done it, as for many of you don't know, in San Diego County, we did away with family law reporters completely in family law for a period of time. As many of you now know, that the law requires family law reporters. And so we have them now. And so I've done records both ways. And I think that in terms of the concern about the record, I share your concern, Mr. Fleischman, about the record on family law matters on appeal, because I've had to do the settled statements on appeal when we didn't have reporters with pro pers. I almost put a fork in my eye, but I am no longer, I think Judge Yu has made a reason under the current state of where we are as a court statewide, Judge, and the way, and the judges are interacting with these litigants and with the representatives, that the record will be adequately protected under your motion as with the friendly amendment.
Does Judge Wiley have a view?
You know, I agree with what Judge Yu and Judge Rubin has said. I don't think that this is going to be an issue, and the alternative is having a court trial with a self-represented litigant. This is infinitely better.
Okay.
Thank you.
Julia and then Julianne.
Am I unmuted? Okay. Thank you. I really like Steve Fleischman's proposal. And if we're going to take out the jury trial, I find that to be acceptable, because it then also allows for the great idea coming from Carolyn, which is if each practice group finds that there's only, Linda, we're taking out jury trials.
No, it's an exception.
Gotcha. Okay. Thank you for that. So I guess what I want to say is, my understanding then is that if we want something additional in each subcommittee, we should prepare a recommendation and rationale for why we would be requiring or suggesting or recommending a different model. And I think this is a much better approach. Thank you.
And Julia, I will just say that the way that you summarized that was better than I said it and is accurate.
Thank you, Your Honor.
Okay, Julianne and then Carolyn.
Thank you. I came here today prepared to support the full in-court representation option. I can now agree that jury trials should not be allowed. I've reviewed a lot of my notes from many of these presentations. I was very persuaded by Sarah Beauvais, the LLT from Washington. I was particularly persuaded by one of the judges that she works with, the Commissioner Lack, who said, you know, these paraprofessionals can prepare a script for the client to read, but when the judge asks a question of the client and the paraprofessional cannot speak, that client has no idea what they're doing, no idea where that information is in this prepared script, can't really figure out how to skip around and just answer the judge's frickin' question. So that was important to me. The commentary of the sitting judges on this working group, especially Judge Yu and Judge Wiley. And Judge Wiley, it'll be a long time before I forget that coffee cup. I have also been persuaded by commentary by Jason Solomon and Tom Gordon, and just my own head. I agree with Ms. Corsetti, who came here from Ontario this morning, who said, we've always had advocacy. To look at this position without advocacy does not make sense to me. I don't understand why advocacy is an issue. The judge makes the decision. It would be a disadvantage to clients if we were not able to advocate for them. And I want to just point out that those clients who came and spoke to us today, they're not talking about wage and hour cases and attorney's fees and mediation issues. They're talking about emotional issues on huge, major family issues in their lives. Dana was going through a divorce. Christina was trying to get custody of her niece and nephew. Michelle was trying to get a conservatorship for her brother. These are all emotional things that these folks cannot be expected to articulate easily. That coffee cup thing, she was so traumatized by that experience of finding that coffee cup in her car that she was not able to even speak. She had to have her sister speak for her. So I can probably get by with Steve Fleischman's no jury trials issue, but I would like to see these folks be able to advocate for their clients. And I think based on the commentary from the clients this morning, that the clients would feel much better about the whole system.
Judge Yu, this is Judge Rubin. Was your support intended as a second of Mr. Fleischman's motion, just so we can kind of keep our record?
Yes, I'm happy to second the amended motion.
We have a typo we need to fix. Ante should be lowercase, slap should be uppercase.
Can I also ask that we clarify that it says?
I'm sorry, Greg, just hold on 1 second so we can let Linda do. And in slap, it's every letter is capitalized.
Yes.
And also if you go up about 3 lines, it says for which they are licensed. There should not be a semicolon after licensed. At most, we can make that a comma. And Greg, please.
And I was just hoping that we could add in-court representation in Superior Court, just so there's no.
Yeah, so we're not talking about courts of appeal. That's correct.
I thought we were going to do it without regulation, but yes, I agree, Greg.
Linda, I think it's in the resolution itself. Paraprofessionals may provide in-court representation in Superior Court. Down, yes. Do you?
So just hold on 1 second. Linda, can you go back in there? So
yes, I thought that's where I added it.
No, it's in the bullet.
Okay.
And just to keep everybody up to speed, we have 22 minutes left in this session.
Yep, but let's let Linda. So yeah, so in that first bullet point.
Yeah. So we have several hands up.
I'm sorry, I need to just be nitpicky. Can you remove the comma after the and?
After judgment.
After summary judgment motion.
The and on that line, take the comma.
No comma.
So we have a motion. Yes.
There should not be a comma after further resolved.
That is the state bar format.
Oh, is that? Okay.
Yes.
All right, let's
I'm
leave
going
it
to have
there.
some changes to mine too, folks. What Leah wrote is not what I proposed, but the bottom one there, I'll wait for comment though. Go ahead. Sorry to interrupt.
All right, let's hear some more substantive comment.
So we have Carolyn, Sharon, and Dana. Julia, I'm assuming this is your old hand, or do you have a new hand?
Old hand.
I saw you take it down.
Sorry.
All right. So Carolyn, Sharon, and Dana.
I'll let Dana go. Darren and Dana and Sharon go next because you haven't heard from them.
All right, Sharon.
Thank you so much. I've been taking in all the testimony today, and a lot of it has really moved me. I come to this working group as someone that spent my entire career in legal services, direct legal services, and now as a statewide support center for legal aid organizations. I also come to you as a former consumer, as someone who had to go unrepresented in family court. I don't talk about it publicly because the experience was very traumatizing, to be totally honest. I'm sorry, I'm getting a little emotional here. I don't think the answer right now is to allow in-court representation, especially in family court. I think this is too soon. I would rather test out a program. No other state is allowing it in family court, so we don't have any stats to base this on. Professor Moore made an analogy of trying to find that sweet spot of where there's a justice gap and also like where paraprofessionals can engage in minor surgery. I don't see that as being in family court. I see in-court representation in family court as being more like open heart surgery than dealing with an ingrown toenail. So at this point, I totally agree with Stephen Hamilton, and I would not be inclined to let in-court representation in its fullest at this point.
Okay, Dana.
I have a quick question. Are we potentially allowing the paraprofessional to draft summary judgment motions but not argue them?
Is that a question for Steve under his?
Has any subcommittee said that they're allowed to draft and file? And now today we are potentially saying yes, but they can't argue them.
I don't recall summary judgments coming up in any subcommittee except most recently in civil. I don't know if somebody else has a better recollection than I do.
That is my recollection, Leah.
I agree with Steve brought it up the last time. We're just starting that discussion. So if in the end our group decides otherwise, it will come out as a recommendation from that subcommittee, I assume.
Can I make another friendly amendment and just jump the queue? Maybe we take out summary judgments because that can fall under the second resolution that the group that's looking at civil can decide that.
I second the second friendly amendment of her honor.
Julia. Do you accept that, Steve? Because then we can move forward.
I'm happy to move forward. Is it your belief, Erica, general civil is the only one impacted by that friendly amendment?
Through my ignorance of family, yes, but I don't know if there are summary judgment motions in family.
There are.
Then family can talk about that too.
I think
I have yet to see a summary judgment motion in 11 years, but
we can do it.
Yeah, I was going to say, it might
happen,
happen.
I suppose.
Could I ask the judges, my understanding is demurs are not allowed in limited jurisdiction court. Do I have that correct?
I've never seen one, and in San Diego, we all help out like in limited jurisdiction and also in small claims, and I've never seen any of that, so.
Oh, there are lots of motions to strike though. Am I next?
Sure.
Yes.
Okay. So I'm going to have two. I'm going to have a comment and then a friendly amendment to Steve's. But I also have, the third thing is I do need to have my resolution rewritten. But the first thing is what Justice Petros said is there's now a higher bar to what we're doing. So as if what we're doing now is going to put again on the subcommittees where we're talking for 1 hour on this issue, right? Maybe an hour or two before. We've spent 100 hours going through every subcommittee, going through all these things. And someone mentioned here, oh, not for family law. Oh, wait, maybe it's for general civil. That's why this is not an appropriate way to handle this. And so how is that working? Now a higher bar, now a lower bar. We don't have any standard or guideline on what this is all going to mean based on these resolutions. Now, that's one comment. The second comment is the way in which I'd like the friendly amendment is this. I'm going to amend this to Steve's motion. All right. I'm going to read some stuff that I've done in nearly every case. This is from my little stash of things I've written forever and ever. Okay, here's what we ought to amend, to include that they can or cannot do. A motion for 473B relief, a motion for attorney's fees, will be paraprofessional fees, a motion for directed verdict, a motion for JNOV, a motion for leave to file punitive damages, get that back up there. A motion for protective order, a motion for reclassification. Sometimes you need a motion for protective order, sometimes you need a motion to quash. A motion for reconsideration, motions for summary adjudication. In addition, do we include that in including motions for summary judgment? Motion for trial preference. That's when people are
Carolyn, hold on. You're going through a series of specific motions that should be, that should be considered within the subgroups. If, for example, the practice area does not allow a paraprofessional to file this kind of motion, there's no question they can't then go in and argue it if they weren't able to prepare it, okay? I'll get to you in a second. So we're not gonna list here 25 different kinds of motions. I kind of question whether we should be having the anti-SLAPP one there either, which we can talk about. Because, for example, a lot of these motions don't even exist depending upon the practice area that you're talking about. And then within that practice area, the decisions need to be made as they're being done. Every practice area has a multi-page, single-spaced line item, what the paraprofessional should be allowed to do or not. And the question is, can they do that motion at all? And so as far as the bigger question that the whole working group should be answering as part of in-court representation, there is the basic issue of if they're allowed, and I think that the vast majority of what you just listed off, they're not going to be allowed to do it all. So of course, they're not going to be going into court to argue them. But the question is that if the paraprofessional is allowed to prepare a certain kind of motion, should that person then be able to argue the very motion that they prepared? My personal opinion is that yes, if we think that it's appropriate for them to prepare it, then they should be allowed to argue it. Noting that I think the vast majority of what you just listed, we're going to not be having them do it all.
To your point, Your Honor, that's exactly is my point, is that this kind of, these 5 or 4 resolutions is not an appropriate way to go back and think through this because it'll be misconstrued. How do we apply it? Where does it fall within all the 10 or 12 different areas?
No, because it says they provide full in-court representation for which they are licensed. And so, for example, if the group has decided they can't do motions for summary judgment or anti-SLAPP motions, then they are not licensed to do those motions. And so then, of course, they couldn't go in to argue them. And I'll come back to you in a second, but Stephen Fleischman, did you have something you wanted to add?
Yeah, I given the comments from a few minutes ago, and I apologize, I think it was Sharon, but I'm not sure. I do think we need to have an up or down vote on the threshold issue of any in-court representation. Yeah. If the vote is yes, there should be in-court representation, then we can, I'll just call it the Fleischman proposal. We can vote and debate on that.
And so when you say a yes or down vote on in-court representation, you're not talking about all in-court representation. You're saying a yes or down vote on whether there should be any representation of any kind at all in court.
Yes. Okay. If the vote on that is yes, then we can talk about how to limit it, how to exclude.
And if the vote on that is no, we can stop this conversation.
Exactly.
And then
you're a mind reader.
The shining proposal, which I started, Your Honor, is that we don't have to decide any of that.
No, I got that.
And we've done it already in subcommittees. So I would say my recommendation would actually be to get to.
We heard you. I think we heard you loud and clear on your recommendation that we not vote on it here. Judge Rubin?
Yes. I would change the language, Your Honor. It's not what I proposed.
Ms. Shining, hi. Ms. Shining framed this as a friendly amendment. In order for it to be amended, both Mr. Fleischman and Judge Yu would have to accept it. If either doesn't, it won't be amended. So I think we have to kind of tie up that in first. And if Mr. Fleischman or Judge Yu are not accepting that as a friendly amendment,
Carolyn, I'm sorry.
Then we can move on to the next part, which is what Justice Patru just outlined.
I'm going to withdraw it and then at some point go to amend mine.
So Linda, so we're taking a vote right now simply on the concept under the first bullet, paraprofessionals may provide in-court representation. Take out full and take out anything after Superior Court. And that
please hold on, because if we wind up having a yes on that, we're going to then be asking Linda to rewrite this whole thing again that we've just asked her to delete. Okay.
I'm not asking her to delete it. She's going to put it in a separate.
Yeah, let's do a separate document. And Stephen Fleischman, I think, is this your motion that, you know, to take the up-down vote on whether there should be anything at all?
Yes.
I second the motion.
Judge Rubin, I'm calling the question.
Before we start voting, I need to finish drafting it, because then I have to turn to recording who makes the
My
motion.
hand up too, in
Okay.
case there's any time.
Why don't we hear from you, Fariba, while Linda's working on that?
Thank you so much. I agree that this project is more than just creating another group of licensed professionals to fill out judicial council forms. Okay, give legal advice. I think there should be some level of advocacy in court for this program to be an innovative, cutting edge program. But I would urge us not to start off with full in court presentation. And I see that the motion was amended. I'm not quite sure where we're going with that, but I'm just going to say my comment. I think that it's really more difficult to pull back from a full blast in court presentation when things don't work out. I think we're starting with a pilot. I think it's a good idea to start with the position I advocated at the last meeting, which is limited in court representation with just responsive to the court's question. I think both the judges and the paraprofessionals can stay within their limits. I'm especially worried about lopsided cases if we allow full court representation. I just don't think, I'm afraid that the paraprofessionals will not be able to keep up with an experienced lawyer on the other side. And I would like us to keep that in mind. Thank you.
Does this accurately capture the motion, the initial motion we want to vote on?
I do not believe so. I personally think the easiest thing to do by far is to do actually an opposite resolution, to do a resolved that paraprofessionals may not provide in-court representation of any kind, period, full stop. That makes it clear, and then we can take an up-down vote.
I would keep the in Superior Court, Linda.
Well, in-court representation of any kind, anywhere, period, full stop. But that's fine to put it within Superior Court.
Right.
And this is not the, yeah,
I'm just worried about administrative courts.
that's fine. Paraprofessionals may not provide representation in Superior Court of any kind. And you can take out the in-court. Okay, so just to be clear, what this says, if you vote yes for this, it means you're saying that there should not be any representation of any kind. And I think it's easier to do it this way rather than try to phrase it with some kind of limited representation or whatever it is, just to get, as Stephen, I think appropriately requested, an up-down vote. So this has been modified. Stephen, are you okay with this modification?
Yes.
And who is the second?
I was, Julia.
And are you okay with the modification as well?
Yes.
All right, then I think we can, Linda, you can take the vote.
And also, Justice Patru, just to make sure our minutes are accurate, and in light of the time and the discussions gone before, Judge Rubin called the question after it was.
Bashan?
Yes.
Reynoldson?
No.
Falmouth?
No.
Fleischman?
Yes.
Hamilton?
Yes.
Judge Harper?
No.
Amos is not here. Kirkmeyer?
No.
McRae?
No.
Olvera?
No.
Robinson?
No.
Judge Rubin,
No.
Shining,
Yes.
Sarush,
No.
Spyro,
No.
Torres Ambris is not here. Judge Wiley,
No.
Judge Yu.
No, thank you, Linda.
Sure. So we have 1, 2, 4, 6, 7, 8, 9, 10. We have 12 no's and 4 yeses and 2 absent.
So that resolution does not carry. But thank you, Mr. Fleischman, for having us do that first. I think that was helpful. And then, are we calling it the Fleischman motion? What did you self-reference it as?
We can call it, we can call it anything you want. I lost track.
I think it's the Fleischman 2.0 at this point.
Yeah. So Justice Petro, the reason I included anti-SLAPP motions is there's extensive case law referring to anti-SLAPP motions as a summary judgment motion in reverse. So
sure.
Okay, so that's where my mindset was. I don't even know if anti-SLAPP motions can be filed in family law or limited jurisdiction. That was my motivation. My big concern are trials, and we've decided to compromise on no jury trials, but bench trials in family law. We'll deal with bench trials in civil in the limited jurisdiction. I mean, in the civil.
So can I have the resolution put back up? Because that's what I was thinking, actually. Thank you for saying that, because I was thinking when I saw the anti-SLAPP that it was tied into the motion for summary judgment, because it is, as you just noted. But again, I really think the question of whether paraprofessionals should be involved with summary judgment motions is a bigger question about whether they should be involved with summary judgment motions in their entirety, as opposed to piecemeal, whether they can draft it versus whether they can argue it. So if we take, if we take out the, if it just says, paraprofessionals may provide full in-court representation in Superior Court in the practice areas. And can you go to where I'm speaking, please?
Yes.
In the practice areas. And for the tasks for which they are licensed, comma, with the exception of jury trials.
Oh, sorry.
That's what she means, yeah.
Yeah, period. And then kill the 2 bullet points that are underneath that, just to give us something to look at, and Stephen, for you to have something to look at.
As a second, I accept that amendment.
I accept it.
We have 60 seconds left.
I think it's the exception.
I have another friendly amendment that's going to sound a lot like the other one.
Sure.
I have a friendly amendment. I'm not going to read them all, but I've got at least 25 motions to add to this.
Here's the thing. Those motions need to be dealt with. And you can say your friendly amendment and Stephen can choose to accept it or not. Those motions need to be dealt with in the subject matter area. Okay, and I want to be crystal clear. I don't think anyone is going to say that if a paraprofessional can't draft a summary judgment motion, that they somehow get to go in court to argue it. Because that's not going to be included in there. That's why I put in here, and for the tasks for which they're not licensed, not just the practice area, but for the specific tasks. So Carolyn, is what you want to read a list of kinds of motions that
it's a point, Your Honor. I'm just trying to make a pure point. If it's not time to discuss them, I'll let it go.
No, it's not. I mean, if you have a specific amendment that you'd like Mr. Fleischman to consider, then you should make that.
I would like Steve to consider making an motion, since we're talking about the exception of jury trials, a list that I could read to add to this. It includes about 30 motions that include extremely substantial issues that will impact a jury trial.
Carolyn, let's deal with it in general civil, because I think it only applies there. I will gladly support you on whatever motions you think should not be handled in general civil. This motion's teed up. Let's vote on it, and then we can deal with your issues in subcommittee.
Even though I wasn't asked, I'm in general civil and I agree. Thank you, Carolyn.
Okay, got it, guys. Withdrawn.
Justice Patru, this is Judge Rubin. I'm calling the question.
Okay.
Okay,
And
and then,
Quick question.
Yes.
By including the term in superior court, are you excluding administrative courts? I.e., should we just cross out?
So thank you for raising that, because I thought that was added to make sure that we weren't talking about we've already made decisions about administrative. So is there a suggestion about how to make that clear here?
Well, we don't.
I can suggest, this is Julia, the way it's treated in 6450 subdivision A regarding paralegals. It states that where there is a provision which permits it in a regulation. So.
Oh, can I, yeah, would it just be simple to do, and Stephen, I'm going to ask you to come back to look at this. Could we simply say, resolve that the following is the default working group position regarding in-court representation in the superior courts by licensed paraprofessionals? And therefore take out in superior court in the bullet point, and therefore making it clear that this resolution only has to do with representation in superior courts.
I accept that.
I do too, and I want to say, Linda, you were prescient when you had it up there the first time.
okay,
Exactly.
all right. Are we ready for a vote?
We are.
I have actually a process question. Are we gonna still go through the other two original motions, including the one about
No one has-
paraprofessionals?
No? Only if someone makes it. I mean, no one has actually moved. So let's get through this and then see where we are.
Okay. Thank you.
Bashan,
No.
Reynoldson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
No.
Judge Harper,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarouche,
No.
Spiro,
Yes.
Judge Wiley,
Yes.
Judge Yu.
Yes, thank you.
The motion carries with 12 in favor and 4 against.
Okay. Judge Rubin, I turn this back over to you with that question of, is there anything further that we need to do with the additional proposals? Or Leah, you can respond to that as well.
Well, just a question, do we consider that we have also approved the second further resolved in that vote?
Well, yes, I mean, I
Yes.
thought,
All right.
I mean, if there was any question about that, then someone needs to pipe up, but I thought we were voting on what is up on the screen.
That's what I thought when I seconded it.
Okay, good.
All right, and when I voted for it, yeah. Ms. Wilson, did you want to weigh in on that?
No, it's just Sharon, you raised the question. We have an approved resolution here. The other resolutions run counter to this.
All right.
So I'm not imagining that it would make sense to vote on them, but I don't know, Judge Rubin or Justice Petru, if you have a thought on that.
It seems like the way to have handled that is that if somebody wanted one of the other ones, they would have voted no on this one, and then we would have just kind of started through each one until we got one that passed. We got one that passed out of the gate. It seems like the question's concluded. Insofar as it now goes to the subcommittees to make some decisions about what's going to happen and then bring the recommendations back. So.
I mean, I agree with it. It seems like it's moot, but if there is someone, and I appreciate that people are staying a few minutes over today, I don't take that lightly. And if there is someone who would like to make another motion, they should do so. We can see if there's a second and we can move forward.
You know, I just chime in to say in terms of my position, the position I advocated for, I think it's a good idea to start with the two extremes. And then if needed, then propose them to the mid-ground motions, but it's not necessary here. I think it's just not a good use of our time.
This makes the other resolutions moot.
Okay, I just want to be very clear that I'm not trying to forestall. If there is someone who wished to make a motion, I'm not trying to cut that off. But I'm not seeing anyone doing so. And so at 1:06, I want to thank everyone. Listen, this is not an easy subject matter. What we're dealing with is very important and very serious and has significant potential ramifications. And I very much appreciate everyone's hard work. I mean, look, every single person who's, who I'm eyeballing on my screen right now, and there are many of you, have put in very, very serious consideration. And I think have tried to think about this big picture, not just from their own particular point of view or what group they might be here to as a representative of. And I very much appreciate that from everyone. So thank you for everyone's hard work. Thank you for staying a little bit over today. And I hope that everyone has a wonderful weekend.
Bye, everybody. Good
Bye.
job.
Thank you.
Bye,
everyone. Bye.